Number one.
Made a lot in particular last order within 1964. Virtually the whole thing has been enumerated, and we are enlightened by the fact that your lordship laid down. My lord, your lordship placed a query about the proportional. My lord, your lordship permits me. So at the cost of repetition, can I read some diagram? I will read 18.2, then I will type one small. My lord, your lordship, whole issue here is about whether in 18.2 and when 18.3 there is the possibility of notice. In 18.2, as your lordship has laid down in para 2, 3, and 4 of last order dated.
Right. Right. Yes.
My lord, the object was whether a notice is required when a person does not get the right of a landholder, settlement holder, proprietor of he occupies a government trust land or wasteland or over, and when there is the government thought that they have no bona fide claim or they are not willing to give him any kind of settlement as enumerated in 12, 13, 32, 30, 34, and 35, and they want to eject them. The purpose of the government is to get the land from the person who is unauthorizedly occupying the particular plot of land, government trust land. But what my submission would be, my lord, a small submission before your lordship is, my lord, whether they are necessary in that there are no alternative measure that can be achieved the same purpose with lesser degree of a restriction. My lord, secondly, there has to be a proper proportionality of balance between the importance of achieving the proper measure and social importance of preventing the limitation on the constitutional right. That is my whole subject. If the purpose that they want to achieve is by throwing me out and get the land, because I am an unauthorized person occupying the particular government of land, if the purpose can be achieved, if the lesser degree of restriction can be imposed by giving me a notice, by throwing me out of the land, that can be achieved because the purpose will be served. The purpose will be achieved. Malad, there in this decision, Malad, 2021 1 SCC page, it starts at page, Malad.
That is which, what's the name of the judgment?
Malad, Aminesh Dekwan versus Union of India. In para 57, Malad, then they have laid down, Malad, Rustam, Koji, Cooper, and others, they have directly laid down, Malad. This is judgment is.
Yes, what's the name?
Citation, it starts at page, Malad. It is 2021 1 SCC, page 1. 2021 1 SCC, page 1.
2021
1 SCC, page 1. Para 57.
Para
Para, my lord, 57. 57, 58. Page 60. In my
Yes. What do you say? Para?
57. May I read it again?
Yeah.
We need not elaborate on this principle in view of the limited controversy involved in the present case, albeit the formulation recognized the benefit and need for at least inclusive measures which it comes to curtailment of fundamental rights. And for this purpose, the court can examine the reasonableness of measures undertaken and whether they are necessary in that there are no alternative measures that can achieve the same purpose with lesser degree of restriction. Secondly, there has to be proper proportionality of balance between the importance of achieving the proper measure and the social importance of preventing the limitation on the constitutional right. My only submission is the lesser degree of restriction. Without notice throwing me out, but they will achieve the purpose. If they give a notice also, they can achieve the purpose. So that will be a lesser degree of restriction in the fundamental right. That is why, Malad,
So why do you need the notice?
notice that by the time, because I will be occupying this land for last 15, 20 years, give me some time so that I can go for a different place. Suddenly, without notice, come and they throw me out, break down my house.
So are you
Notice
saying
means that time period,
Time period,
only time period.
that much. That is
Not that I need a notice to explain my position.
my lord.
This is not the case. Your
Not the
case is that I will
Because it
get
is,
evicted myself.
because it is 18-2 is my lord. Here is the wasteland. I don't got any right as a proprietor, landholder, settlement holder. I have no right. Neither I have any bona fide claim. Neither I have applied for.
what do you mean by bona fide?
That I have applied for, my lord, settlement, as your lordship has held that 12, 13, 32, 33, 34.
Yes.
But
But what do you mean by bona fide?
what a bona fide claim, my lord, I have applied for those land and it is still in process. So there is the claim. And your lordship, as per the land policy and other provisions of this some land and revenue regulation, they can settle the land with persons they have applied for. There are provisions in the land and revenue regulation and in the land settlement, the land policy of 2089 and thereafter in 2019, that if somebody in possession of a particular plot of land, that can be settled. And if I have applied,
What is this land policy? What is the value of a land limit?
land policy is the only thing that is a guidance to the effect. It's not that I have any right over it. It's only a guidance for which the government on that basis of the policy can act on a.
So isn't it your right to get a settlement on the basis of the regulation?
My lord, here in some provisions of the Assam Land and Revenue Regulation, if I read, my lord, 32, 33 and others, my lord, as your lordship has laid down in the last order, my lord, where it states, my lord, with your lordship permission. (32) To whom settlement it to be offered. The settlement officer shall offer the settlement to such person, if any, as he finds to be in possession of the estate and to have a permanent, heritable and transportable right to use of an occupancy in the estate, or to be in possession as mortgagee or person having such a right. Malad, this is 32. Then Malad, 33 is Malad, acceptance or refusal of the.
Yes, what you were referring to? 32.
32, 33, 34, 35.
Hmm.
32, my lord, Assam Land and Regulation. Regulation 32, to whom settlement is to be offered.
So the settlement officer shall offer the settlement to such person, if any, as he finds to be in possession of the estate, and to have a permanent, heritable, and transferable right of use and occupancy in the same, or to be in possession as the mortgagee of a person and having such right. So this is immaterial of this is to be only constricted to those persons. This settlement is to be given. This is more like a heritage.
I
This. Then if settlement officer finds no person in possession as aforesaid, it shall be the discretion subject to such rules as the state government may make under section 12 to offer settlement to any person he thinks. So this is a very wide power being given to any other person who does not hold any hereditary right or an inheritable right. Isn't that? Then your right to settlement accrues from where? Only on the basis of the land policy.
So this is that if I can say,
You have not prepared yourself. No. Now kindly come to rule
settlement rules, section 12 and 29.
section 12. What does it say?
Settlement rules, section 12.
No, not settlement rule. Come to the regulation. You have read 34, 32. 32 says about heredity, or number 2 says
Any person
any other person. Now, who are the persons?
that has who are the person, maybe a person who is occupying the plot of land.
Kindly come to rule section
12.
section 12.
Power to make rules for disposal of government land and adjustment therefore of unauthorized occupation. In the case of any land over which no person has the right of proprietor, landholder, or settlement holder under the state government may make rules to provide for disposal by way of grant, lease, or otherwise of such land, the ejectment of any person who has entered into unauthorized occupation of such land, and disposal of any crop raised or any building or other.
So these settlement rules are being made on the basis thereof.
Yeah.
And it is to be given to whom?
Allowed
Those persons who do not have these rights.
this right.
If that be so, that is why you find the same wording out there in Rule 18.1.
Correct.
Then your bona fide claim arises from where? Well,
12. Correct.
32.1, 32.2.
Two.
Then
12 reduce.
why you are going into the land policy?
Absolute. Sometimes I get confused.
Huh?
Get confused myself.
There's nothing to be confused of that. You
But
have
12,
been, we have
32.
given you due time to prepare this matter.
12, section 12, 32, 2. 32 provide that, Malad, 32, 2. Any other person. And this,
Now show me that. Kindly come to. Now, how are you importing the principle of proportionality? How?
Malad, proportionality in this sense, Malad, because since
Because we have mentioned it in the order.
no,
Then
no,
you have to import it how?
Malad.
There has to be a link.
Malad.
How do you import it?
Malad, import in this sense, Malad, we are in, if we read as your lordship says 12, I don't have that settlement holder, proprietor, or landholder. By 12, I am in possession of a particular plot of land. And in 32.1, they have the right settlement holder as the person, settlement officer has a right to settle my plot of land with me. And I make a claim or apply for settlement of the plot of land. Now, during that time, if they come and throw me without a notice.
Again, you are coming to the second portion. You are coming to something which is happening now. But how do you link? You have to link it. How do you link the principle of proportionality? First, there is no challenge to Rule 18. If there is no challenge to Rule 18, how do you bring in the principle of proportionality?
Only my submission that was, my lord, because at the very initial, I made a submission, my lord. If, my lord, they, when I don't have, there is no challenge to Rule 18 and others, my lord. Now, the question is whether are two judgments which are differing from each other. One is that Sundarangam, and other one, 18 and 2006, my lord, whether a notice is required or notice is not. at
And
all.
what is the notice you are referring to? You are asking this court that Rule 18.2 should be treated like Rule 18.3. How can that be possible?
My lord, that is that.
Isn't that the legislators' wisdom out there to make Rule 18.2 separate from Rule 18.3? How do you bring in?
That cannot be done. My lord.
Then-
only thing, my lord, with that lesser degree of restriction, my lord, some kind of time provided for the person to throw out.
Wouldn't then be transgressing into the legislative wisdom of 18.3, which gives only 15 days?
15 days.
You see, have you read what is Rule 18.3?
My lord, my lord.
What does it say?
Hello.
Without reading it.
No, my lord. 15 days that is there.
Why? 15 days for what?
To note, the notice referred in clause A and subrule C above shall be published by affixing such and such. In all of the judgment shall be preceded by publication of a notice in the manner prescribed below, requiring the occupant generally to vacate the land specified in the notice
No,
within
it is
15
only
days of the date of
15 days is given for vacating the land.
Vacate.
Why?
Because-
You are asking that. And the word used is in other cases, meaning thereby when there is a bona fide claim.
Bonafide.
Now, is a suit barred to challenge Rule 18? Action under Rule 18.
Suit.
Suit barred. Where will a person go? Mr. Roy Chaudhary, you are standing out here not just only holding that brief. You are arguing before this court as regards the entitlement of a person. Whatever you argue today will have a far-reaching consequences on others. It's a question of law.
My lord,
You see what happened in Radhakanun's judgment. Radhakanun,
my lord, 1996.
why? What happened in that case? Do you know?
My lord, because Koji Bahira has
No. You have to see out there. The matter was done out here in the division bench. The division bench held that he has a right. Matter went to the Supreme Court. Supreme Court now appeared on behalf of the respondent. It was only an amicus who made the submission. And it has resulted in this.
is a penalty.
You have not read that judgment, or you have just read the last portion of the judgment.
I read the judgment.
Last portion.
No.
Who was the amicus?
That I
Then? You didn't read it. So that is the big problem. And you are shouldering a huge responsibility. You can't come up in this manner and argue this matter. We
Alright.
expect something more than that. How do you link the principle? You have come up with a principle of proportionality. Principle of proportionality says you don't need judgment. The simple aspect of principle of proportionality is if an administrative action is being taken, that administrative action should be taken in such a manner that it is least effective or pervasive. That's the simple reason of proportionality. Because the action of the state has to be fair. And this touches which principle? Article?
14 and 20.
14. And how do you bring in 14 here?
Because two are separate.
How do you bring 14 out here in Rule 18?
Because 18.2 and 18.3 are two different.
You see, when was this settlement rules made?
That amendment was of
Forget about the amendment. Amendment has come now. When was the settlement rules made?
1886.
1886, the regulation.
Regulation.
Then settlement rules made when?
The rules.
You have to see, you see, the power is on the rules, the section, the regulation. The regulation gives the power to frame rules. Now, can the rules be in such a manner by which the entire powers of the civil court is being taken over without due process?
Right.
Why? The rules were first made in 1894. You won't find it there in that book. There were many rules made. As per the section, there were around 12 or 14 rules made. Thereupon, on 6th of April 1931, a consolidated settlement rules were made. At that point of time, these Rule 18 had featured. You had which other lands which were there? Grazing ground, roadside land. Why roadside land? Have you seen Rule 22?
Timber resignation. Rule 22 is there.
What does it say?
Rule 22, rules.
Hmm.
Refund of value of timber on resignation of a land.
No, not that.
Rule 23.
Rule 23.
Roadside land.
Rule 23 at that point of time had that you only see the difference out there. Rule 18 at that point of time which had roadside reservation, grazing grounds. These are lands which cannot be settled. Do you know why? See Rule 23. It categorically mentions that these land cannot be settled. And that is why the power has been given to the revenue authority. Therefore, when a bona fide claim is there, what is the impact? Is a suit barred?
My lord, here the rule says that, my lord, we cannot file a suit to challenge this.
Where is it?
It is not, my lord. What I understand, my lord, that rule is barred to file a suit challenging.
Where?
154.
154 says what?
Matters exempted from cognizance of civil.
Where? Which provision? (154)N. Isn't it?
Well,
Now tell me, if you have a bona fide claim, would Rule 18(2) come?
but here 18 says who doesn't have a bona fide.
That is what. Rule
Then
18(2) will only come when you don't have a bona fide. But
When
if you have a bona fide claim,
then 18.2 will not.
18(2) won't come. Then if 18(2) doesn't come, 154(N) will come.
No, man.
Therefore, what happens a person when he has a bona fide claim? So the bona fide claim, therefore, has to be either mentioned somewhere. Now, on one hand, the wastelands are allowed. That is why this court we have recorded. On one hand, you don't say in any of the regulations that wastelands are not to be settled. On the other hand, Rule 23 or the grazing ground, it is there. When there is a specifically, just for example, that particular land has been given to the PWD to construct a house. There, in that case, the question of settlement does not arise. When there is an order specifically, look here, Mr. P.K. Roy Chaudhary, you don't enter this place, or you have entered, then also you enter. Then there is an order by which you don't require a judicial process. The principles of natural justice does not have a role. But if you have a bona fide claim, if you have raised a structure out there, a 3-story building, openly in the eyes of these people, then you may have a bona fide claim. Then would the sea be barred under 154? Or would it come within the ambit of 18.3 that you will be given a 15 days notice? Look here, you demolish the entire 3-story building.
That also. No, man. 18C also. No. Because
So how do you develop your concept of bona fide claim? Because otherwise, what is happening, what would happen otherwise if we just hold it, that the revenue court can do, the revenue authorities can do, you'll be giving the power to the revenue, the DC to do whatever they feel like. Would that be permissible?
No.
And the bona fide claim will be a dispute by which requires an adjudication. How do you adjudicate?
there should be some authority to adjudicate.
But you have come up out there, just give me 15 days notice, I'll go away. That is your submission. Without taking into account that you are shouldering such a huge responsibility.
Because subject to my lord.
You're
Going down
confused.
No, with going down my head, my lord, I placed that, my lord, because the issue was only a notice was required or not. That was why, my lord, because your lordship now has dealt up with this matter in totality, saying that, my lord.
You see, the notice is required. Everything emanates from the notice. If there is a notice, you can very well say that where you have a bona fide claim. If you have a bona fide claim, then you are maybe required to take new recourse.
Correct.
So the question starts with the notice.
No.
But can you say that tomorrow morning, well, look here, these people are there, we just throw you out?
So your lordship has now dealt with, in firstly, my lord, in thorough, they're saying that when there is a bona fide claim, your lordship has stated that 150.
I have not stated anything.
My lord.
I have not heard the other side also. I'm only asking you that, or making you very clear about your responsibility before this.
And
That
if you
not-
think that responsibility should be shouldered by us, we'll do that.
No, no, we will definitely, I will definitely take care.
But
Alright.
we are in a division bench, leaving aside our single benches for an important issue.
Because, my lord, now the issue has been transmitted to that portion, my lord. From notice that it has gone to other portion, that, my lord, that whether that bona fide claim, man, if it is, I have a bona fide claim, I have 18.2 is not under challenge, neither 154N has any restriction over it, and others, my lord. Now, whether this particular thing, my lord, whether the person who has a bona fide claim can have on notice that the starting point have some kind of, my lord, your lordship.
No, without a notice, how will the authorities know that you have a bona fide claim?
Yes, correct. That is all.
Now, how do you bring in that concept without a challenge to Rule 18.2? How?
That is true, my lord. You have to challenge this.
My goodness, again. It seems that Mr. Roy Chaudhary, we may have to go there and ask you to sit here. You see, that is why the principle of proportionality comes in.
My lord.
Principle of proportionality is Article 14. Article 14 is because Article 13.
My lord.
And any law which have been made earlier, that is why I gave you an indication. This was made on 6th of April, 1931. The pre-independent laws, you have to read it with Article 14. Otherwise, it goes without a challenge also. So in order to maintain the provision out there, you have to bring in the concept of Article 14. You don't need to challenge. Have you gone through the judgment of Media 1? I made it very clear to you last time.
That time.
Right?
My lord, only going through this, my lord, principle of proportionality you have clear. I have gone through those things. As big as bona fide claim, my lord, I'm sorry that I have not gone through that, but you lordship will
That
give-
is the most pertinent question, and that was my first aspect which we have recorded in our order. How do you know what is a bona fide claim without a notice? Because you can't just think today, okay, these people we are just beating the drums out there and say that for 3 days after you are going to Twitter. That's also a notice. Then at that point of time, you realize that look here, we have a bona fide play. I've raised a house of 3-story. This is a land which can be very well settled. Maybe whether I apply or not, that is a different thing. I may apply. I have a right to apply. When there is a law that you can apply, so a right would accrue upon you to apply. Merely not applying does not take away your right. The right is there.
Well,
you may still have a claim. What is a claim? A claim is a right.
Right.
If that be so, whether you file an application or not, you can very well file an application tomorrow.
Yes.
So under such circumstances, how will you apply or do anything to the effect?
My lord, what I can say is that, my lord, on that issue, to Lordship give me some time.
Mr. Roy Chaudhary, we are not satisfied with your submission, the manner in which you are dealing with the matter.
My lord, your Lordship will
We are
give me
very
some-
sorry to say.
my lord, give me
You
some
are
time.
to be more prepared in this matter. And that too, when we have made it very clear that what is that? What is required for you to address? We can't just put it everything to you. That look here, you argue this way, this way, this way, this way. No, nothing to it. Or you wanted on the last occasion, I point out all these things and then ask you that you, okay, Mr. Roy Chaudhary, now you argue what we have already argued and put it out there in the order. Something like formulating a substantial question of law. And that has already been done. So now you argue whatever it is. Without that substantial question of law being a part of your draft, substantial questions of law in your second appeal. Yes, Mr. B.D. Rekha, come here. You have, are you doing any matter on Rule 18?
I have done in the Malot that eviction rule 18. Yes.
You've done?
Yes.
Is there any matter pending out there? Out here?
No, nothing. But
We'd like to make you an amicus in this matter. In this matter. We will require this thing to be addressed out here. That what is the right of a person under Rule 18.2? Because the aspect of bona fide claim is
of
there.
right. In fact,
That how do you take care? Whether because of the bona fide claim, can the person then take away the bar under 154(1)(n), the 154(n) goes away? Or how do you read Rule 18.3, where it says that in other cases, would it mean cases falling under bona fide claim also? Because you see, they did not amend Rule 18.3. Although they made, in 1961, they made an amendment by making it 3A and 3B. They made it. And certain other aspects have been brought in. But the thing is, they did not amend in 1997.
Right.
1997, what they did, they brought in all within the ambit of Rule 18.2. Then what is left in Rule 18.3?
in fact, my lord, another aspect I had thought of it, my lord, how do they even decide bona fide claim of right without putting the person to notice?
That is the specific question we have put and we have recorded in our order as to how a person will know, or the revenue authority who is going to decide will know that he has a bona fide claim without putting him to notice. Yes, Rule 18.2 as it stood prior to 1997, the question of bona fide claim, any other claim did not arise because of the fact that the rules categorically mentions that these roadside lands or grazing grounds and all these things cannot be settled. But you are bringing in karst land and wastelands, which are to be settled. And if these are lands to be settled, then how a person may have a bona fide claim? And if it is comes under the bona fide claim, can it be the civil court bar, the bar which is there in the civil court is lifted? Just for example, let us take the example of the Public Premises Act. Public Premises Act, the government has the power to throw a person out who is there in the public premises. Very well. But the moment he has, and public premises also includes the land. Okay. Now, if that be so, but you have an estate officer there who will issue a notice under Section 4 and then take a decision under Section 5.
With evidence.
With evidence, whatever. I mean. But the thing is, the moment you raise a bona fide claim, it goes outside the scope of the Public Premises Act. Then you can very well file a suit. Now, the incorporation of the word bona fide claim, would it take out or the bar which is there under 154N? And all these emanates from the notice. So this aspect of the matter, we'll like you to assist us on the next. Mr. Barbujari will hear you on next date. We pick another. We have made it clear what are the things we will require you to find.
Parameters have already been set out by my lord's order, last order, my lord. Last order. it is
Just
like-
look into that also aspect about this. How do you construe the term bona fide claim? Because while just making our aspects clear out there, it just recollected about that public premise. Because the moment there are many judgments of the Supreme Court, moment there is a bona fide claim or a person has a claim out there, it goes outside the office of the public premise.
Because the lordship will kindly mark a striking difference in the public premises, because in public premises act, the very fact of public premises is defined,
That involves also includes land.
land.
Remember.
But here in 18.2, it is not as such. What would be the bona fide claim? Under what parameters?
No, there is also not there. In public premises also, what is there, bona fide claim is not there.
Okay.
Bona fide claim, in fact, is not mentioned in the Public
Okay.
Premises Act itself,
Absolutely.
but it has been evolved
By the court.
by various judgments of the Supreme Court saying that if a person has a bona fide claim, then you cannot go ahead under the Public Premises Act.
Absolutely.
And this is the only aspect which is being dealt with in the first appeal, which is done under 9.
Yeah.
That is that. Now, here it has already been statutorily recognized about the bona fide claim. How do you treat this term to be a bona fide claim and what is the parameters of that? Because only problem out here is how do you deal rule regulate section 12?
Section 12, because I will make an attempt to draw my lord's attention to my lord the coherent reading of all the rules. That will my lord crystallize as to what may be a bona fide claim. Because a bona fide claim will have to, in my respectful submission, from the provisions of the rules and regulations itself. That will have-
Yes, no, in fact,
I
they
cannot-
had prior to
cannot bring any foreign
1993.
claim. I cannot import any foreign claim as a bona fide claim.
No, absolutely. Not a foreign claim. But just for example, a squatter tomorrow stays out there in a wasteland, he cannot have a bona fide claim. The bona fide claim we can still import it from section 434 or 433E of the Companies Act. Wherein also it has been said that if there is a bona fide dispute, then it goes outside the scope of 433E and 434 of the Companies Act. So we may have to develop on that aspect as to what would you mean by the bona fide? Because you see, wherever there is a bona fide claim or anything bona fide used out there or a bona fide dispute being raised, it goes outside the scope of the summary jurisdiction.
Absolutely.
Everywhere. In all cases you find,
Absolutely.
and just for example, in a writ petition also, in certain aspects, you cannot decide those. It has to be left out there to the executive to do that aspect of the matter in a writ petition.
Absolutely.
So same here also, if it is a bona fide claim, it has to be an adjudicating authority by which evidence are to be taken. So we have to now understand how do you take care of that term bona fide claim.
And once a person, my lord, is able to assert, or for that matter, establish, my lord, a semblance of at least bona fide claim, bona fide right, then, my lord, my respectful submission will be, it is only then, my lord, the principle of proportionality will follow.
Absolutely.
Because
But how?
bona
No.
fide claim will be the
Principle of
consistent
proportionality will follow only on that
Yes.
because he has a bona fide claim.
Yes.
There's no quarrel with that. But the problem is, if that is so, the principle of proportionality is to be followed out there if there is a bona fide claim. But how will you know that he has a bona fide claim without a notice?
Who will let you know?
My lord, I will be inviting my lord's attention to the rules. I will open my cards on the next.
No, it's okay. I'm just, we are just expressing, we have not decided anything. That is why, yeah, okay. The matter, when do we fix it? Because the term in all other cases of 18.3 assumes very irrelevance. Why the term in all other cases? Yes, that amendment was not brought in after bringing in 97. That was brought. So just try to find out the statements and objects for 18.3. Because 18.3 was initially 18.3, but it has now been bifurcated in 18.3A and 3B by the 61 amendment. So just find out.
Now both 18.2 and 18.3 have become mutually exclusive.
It becomes one and the same. In fact, there also, Mr. Roy Chaudhary will only like if he is brought within the fold of 18.3. That is his initial. Okay. The matter upon being heard, this court is of the opinion that an amicus may also be appointed to assist this court, more particularly taking into account the import of the word bona fide claim in Rule 18.2 of the settlement rules, and as to whether a person who has a bona fide claim, then the bar under section 154N would be lifted. This court, therefore, appoints Mr. B.D. Dekar, the learned counsel, as an amicus. This court, we have therefore requested Mr. B.D. Dekar, the learned counsel, to assist this court in the matter, and he has readily agreed to do so. Consequently, this court therefore appoints him as an amicus curiae in the instant proceeding, and the registry shall show his name in the cause list. Further to that, the registry is also directed to furnish him a set of paper, the materials before this, the pleadings, as well as a copy of the order dated 19/3/2024, as well as the instant order to him within 7 days. When do you want it? Yes, Mr. B.D. Dekar.
My lord will have it this month.
Huh?
Lord, towards the end, probably 30th of May, if it's not
Too long.
too long.
21st May month.
23rd, can it be 23rd?
We'll have it on 14th of May.
It is a holiday.
14th of May.
14th or
16th.
16th.
16th of May.
16th of the year.
16th of May. Item?
Item number 4, Your Lordship.
What happened?
He's been admitted since last Friday, Your Lordship.
Who?
Mr. D. Chaudhary, Your Lordship.
The other advocate.
Sir, Your Lordship, they have left chamber. Mr. M. Chaudhary is with Mr. D. Chaudhary right now, Your Lordship.
Who?
Mr. M. Chaudhary, who is in the court list. He is with the D. Chaudhary. He's the son of the D. Chaudhary. So he's also with the father at in hospital, Your Lordship.
Okay.
Your Lordship, madam, for 4 weeks, Your Lordship.
It has been informed to the court that Mr. D. Chaudhary is hospitalized. that the deed Chaudhary, the learned counsel appearing on, who would be appearing on behalf of the appellant is hospitalized. And as such, the matter cannot be, and as such, has sought for a short accommodation. The instant second appeal is of the year 2008. And under such circumstances, this court adjourns the matter. In 9th of May 2024. On that day, the appellant, if Mr. on that day, the appellant, if Mr. D. Chaudhary is not in a position to argue the matter on that day, the appellant shall make alternative arrangements.
Lordship, I beg to mention item number 12, Lordship. Lordship, senior counsel Mr. Retrospective was not able to come today, Lordship. He physically is not well, Lordship. And we have taken concern from the other side, Lordship.
I'm not going to adjourn this type of matter.
He is
Somebody is
hospitalized.
hospitalized, then you say. Hospitalized?
Yes.
AK Putta is hospitalized?
Yes, Lordship. Yes, yes.
Which hospital? Don't make a mention.
Just phone call.
I mean,
No adjourn. Hospitalized, then it.
Lordship, we have taken.
may take to mention item number 2, my lord. Here, my lord, the respondent has died. I have informed the appellant, my lord.
When?
My lord,
When did the respondent die?
his legal heirs informed me over telephone that his father has died last year. Gota Bosor means last year, my lord, probably.
We'll take up when the matter is. If it has abated, we'll close.
May I please, Lordship? I beg to mention item number 10, Lordship. Kindly pass over the matter for the 1 week here.
Why?
Because my senior is suffering from illness.
Who?
I'm J. Chaudhary. I'm a J. Chaudhary.
Suffering from what?
I'm taking cook from the concern other sector.
No concern business. This matters, I don't adjourn. No adjournment in this matter. You can, anybody wants to mention these matters which are new ones, 2000 year, nothing. Otherwise, all matters would be taken.
May I please, Lordship?
Because anyway, these matters won't reach also. There will be many other matters. We'll accommodate you, but I'm not going to adjourn. Okay? But there is also a reference also today.
Yes,
Lordship,
So don't worry. It may not be.
9 and 10 at another.
No adjournment.
I'm not.
May I please, Lordship, my senior is after prison, Lordship. Item number 9 for appellant and item number 10 for respondent.
No. Next thing. Yes, Mr. Sayavala, your matter. Yes, what do you have to say?
For listing of an I,
For what?
the restoration of make appeal. It was
Go. Mention it in court number 22. Mat appeal.
Mat-
Matrimonial. Okay. When do you want?
6, 5.
8-5.
Okay.
Lord, the policy was that, my lord, the subsidy is on the plant and machinery. That's the policy, my lord,
Hmm?
Policy was that subsidy will be on the plant and machinery.
They clarify.
Now, I'm coming, my lord. Now, this has been, my lord, because in 2007 itself, my lord, they have clarified that, my lord, what is, my lord, extent of habitual subsidy. That is a paid subsidy, my lord.
Now, they have not amended the policy. They have not amended. They have stated in the affidavit that there is a power to amend the policy. But they have not done. Now, they have ultimately, my lord, in 2013, they have issued a circular, and nowhere it is written that it is
Hmm?
retrospective. It will be retrospective. Nothing else. And here, my lord, some important plants of the stage of the plant, my lord, has been excluded. Just like kilo, hoopar, they are also excluded. My lord. Many other items are.
Earlier, we see this annexure A1, page 26.
Yes.
There is no definition of what is plant and machinery.
No.
It only says
At
at page
20,
20, 30, plants and machinery for manufacturing unit. In calculating the value of plants and the cost of industrial plants and machinery as directed at the site will be taken into account,
cost
which
of
will
productive
include the
equipment.
cost of productive such as heat, mold,
Tool,
interest,
kits, dies, mold,
amount
premium, etc.
invested in goods carrier to the extent they are actually utilized for transport or when so will be taken into working capital, including the raw materials and other work area will be excluded. Definition of plants and components which should be given, taken into account for the purpose of the scheme in respect of
See, they
service
had
sector,
created a normal-
area and power generating industry referred to in 12 also would be notified separately. So you don't come under the service, biotechnology and power
No.
generation. So it will be as per 6, 1, 2, and 3.
Correct.
Now by amendment,
Yes.
which of this particular thing is being
Now, yes.
impugned or affected?
My lord, now you will also come to my lord, page 96.
Page 95,
95.
which will not be considered for computing the value of plant and machinery under CCI. Loading and unloading charge. It was already not there. Earlier, was it there? Amount invested in goods carrier to the extent they are actually utilized for transport and marketing of the finished product is taken into. Sheds and plant and buildings for plant and machinery.
Now, my lord, Roman is very important. Electrical components necessary for plant operation on plant site from where meter is installed up to the point where finished goods are to be produced. Dispatch AC motors, switchboard, panel, capacitor, relays, breakers, panel board, switchgear. Everything is and pay charges paid for doing material transfer, rented interest, amount invested in the goods to extent actually utilized for transport of raw materials and power. Now it is page 96.
Yes.
Now,
Now, what do they say out there in the
yes, my lord, that I am coming now. my lord. Now, if your lordship will see, my lord, first take the affidavit of response number 3 to 6, my lord. At page 1.
What does 1 and 2 say?
Yes, 1 and 1 and 2, my lord. Your lordship back, my lord. Yeah. At page 151.
Eight.
Page 151.
Who is this?
Here, my lord.
It is the affidavit of
1 to 1 and 1 and. You know? Here, my lord, they have made some visit and they have come to this, my lord. My cost, my lord, they have found, my lord, 120 crore and odd. So here, as per the inquiry report, eligible fixed capital investment for CTIC is 58.5.
which have been removed.
Now, my lord, next, my lord, there was next page, my lord, 153. The clause 6. CIC report and field visit, demand meet. Field visit, the 1941, it has reduced by 239.20. Here,
This
my
is
lord,
your-
your loss will find.
This is for whom? Cement mill is who?
Yes. Considering the CIC breakup of non-eligible items under plant and machinery like fire per, thinker per, system per, top pen, etc., which amounting to rupees 20 are deducted. Hello, this is absolutely correct, my lord.
You have been paid how much? 14 lakh. 14 crore.
14 crore and all.
You have got.
Yes.
Your claim is something around 20 crore.
At this, my lord, in the field visit, my lord, they have found it 58 crore and all, and now from there also they are deducted. Then clause 5, my lord, you'll also see page 153. Cement mill hooper. Hooper, which is a non-eligible item. Whereas, my lord, this cement mill hooper is included even in 2013 also.
Two thousand.
I think notification also, my lord, some are included.
Fly ash, hooper, clinker.
Yes, my lord, these are limestone hooper, conveyor, and so then all raw materials like feeder below hooper, separator, fence, and so. Hello, many things are there. Now they have removed my string, even cement mill hooper, my lord, that like
So they have reduced from these two, na? 1, 5 and 6.
Yes.
Isn't it?
1 5.
You are agree because of that.
This is one, my lord. And now your loss will come next page, my lord, 154.
Yeah.
Electrical installation 746 they have reduced, saying the out of total so and so non-eligible item like DG house, panel, and cable and tube light, etc. amount is rupees 20. My lord, light, I don't understand, my lord. Then masonry foundation also, my lord, they have jacked that.
Electrical installation is out by 2013.
My lord, yes. Yes.
Yes.
Electric nations are there.
Not there.
My lord, yes, yes, lord.
Kindly come to annexure page 96.
96, my lord, if you
If you kindly see
electrical
this one.
others, my lord, G6. Electrical and other,
No. Kindly come to B3.
my lord,
B3.
P3, yes. P,
Miscellaneous fixed assets such as DG, excavation, mining equipment, handling equipment,
That DG
electrical,
side, madam.
etc.,
That
other than those mentioned in A3.
yes. A3, they are electrical components necessary for plant operation. My lord, if I take electric line, my lord, from the board, my lord,
Hmm.
the transformer and other things, these are necessary items, my lord. So
Now
these
they are giving it for HT motors, LT motors, switchboard,
Yes.
panels, capacitors, relays, circuit breakers, so and so they are giving.
These are remote, my lord. Many items I shall come, my lord.
Huh?
I shall come. Many
But
items
they are taking out the tube light in business.
here is tube light, my lord.
Easy House, MCC
Yes.
panel.
Here they have removed, but other, my lord, if you also come to 3 to 6, my lord.
Hmm.
The affidavit.
Hmm?
They have personal 6 affidavit, 3 to 6 affidavit. At page 164 it starts.
What is the additional affidavit file? What do they say?
They say, my lord, only it is retrospective. That is the only.
Yes, what do they say?
Now, your lordship may come to period of 3 to 6,
Hmm.
which is at 164 chart.
Hmm.
I shall come to page 252.
Page
Page 250. Statement of ineligible item. And it's a
252.
Yes.
There is no 252.
annexure Roman 3, my lord, P1.
Yes.
Yes. If your losses comes to, my lord, total cost of a machinery, foundation cost, eligible as per engineer certificate, my lord. It was, my lord, 12 crore and odd. They have it's 16 crore and odd. It has brought down to 12 crore. I do not know what engineer certificate. Similarly, in the foundation cost, cement mill hooper, they have excluded, my lord, 44 crore and odd. They brought it to 13 crore. Again, my lord, item number 4, cement mill take foundation cost, my lord, is 7 crore. They have brought it to less. 3 crore and odd. Total cost of machinery also they have brought it down, my lord, from 54 crore and odd. 51. Then the next page 253, if you'll also see, many things has been said that in this item. I do not know why it is in this item. As per DIPP, not as per that. They say as per DIP. 253. All items, my lord, they say only as per the item.
This is the performer for agenda notes to be submitted to the Imam and the secretary of the Imam. This is done when monitoring form page 234 or 285. 285, 234. Whatever may be, the question arises out here.
Now,
These
again,
intricate details this court is
it's
not going to go into.
some item I
Question
say, my lord.
involved out here is as to whether the document which have been made in 2013 is clarificatory.
Yes, sir.
If it is clarificatory, it will date back. If it is not,
I'm some other items, my lord, I'm it- electrical care, electrical. No, sir.
because what
My lord, if your office comes page 263,
no, Mr. Sahiwala,
Yes.
what you are challenging is the 2013 office memory.
Correct.
That saying that that cannot be made applicable to you.
Well,
That is your challenge in your petition.
Correct.
This court is not going to go into those intricate details where which is to be required or not.
Well.
Whether 2013 could have been made applicable to you or that is the sole question.
Well.
It can be applicable, you are up. If it is not applicable,
Correct.
then you are.
my lord, my submission is, my lord, what,
So what is your ground?
now, my lord, my submission is this, my lord, without changing the position, my lord. They cannot remove many items, my lord, because I have annexed a copy, my lord, that hoopers are there in the bill itself, my lord. And the policy also says, my lord, some hoopers are there. All hoopers are excluded, my lord, now.
That is
Hoopers-
another aspect.
Well.
Hoopers are, that is on individual aspect.
25.
Your basic case is on 2013.
Yes.
If 2013 is out, you are in.
My lord.
So that is what you have to show before this court that 2000, that there cannot be any amendment being made without challenging the policy.
My lord,
The policy, no, it is it is not the policy, it is the notification. Without amending the 2017,
Yes.
they cannot.
I'm pressing a few judgments, my lord. Earlier, I had submitted 122,723 only.
That,
Now,
that is long time.
One, my lord, number one is, my lord, our High Court judgment against which, my lord, SLP has been prepared with it. By considering various Supreme Court judgments, my lord,
Which one?
my lord, just comparative, my lord, there are 26. Huh? Here, 6.8.
2018.
Yes, my lord.
480.
2018,
What does it say?
they considered, my lord, 23 onwards, my lord, they have considered the Supreme Court judgment, my lord.
Hard mistake is submitted by the
And ultimately, at page 26, my lord, it says that. Like, transport. Like,
Now, what does the policy say? You see, this judgment of Justice Goswami is a judgment in respect to the policy vis-a-vis the notification. Here, that is the CCI scheme 2007 is a notification. A notification is being amended, not the policy. The policy never says.
policy never changed.
So it is the, how do you imply this judgment of
This
Justice
is, my lord,
Goswami?
what, my lord, this judgment, my lord,
Finally come to paragraph 25 and 26.
yes,
He has said that when the policy has been made,
Yes.
wherein it says that there will be a 3% subsidy, interest
Yes.
subsidy,
Yes.
how can, by way of a subsequently doing it, they can limit it by saying only that it will be given to those 3% only to those persons who have increased. Now that he says that they would be going against the policy which had the cabinet approval. But here it is not against the policy because that notification is not a policy. The policy is there. The policy never
my
says.
lord, plant and machinery.
Huh?
Policy is plant and machinery.
Policy says, does it say that all the plant and machinery? Where is it? Let's see the policy.
Like the page 20. Page 26.
Huh?
Page 26, Roman. Capital invest subsidy to enhance from 15% of the investment in plant and machinery to 30%.
Capital will be enhanced from 15% of the
Automatic
investment in
approval
plant
subsidy.
and machinery to 30% of it. And so, we are concerned with
Yes.
number 7.
Yes.
Capital investment
My lord,
subsidy.
Number 7. Number 7. So investment in plant and machinery.
Where?
This is, my lord, capital investment to enhance from 15% of the investment in plant and machinery to 30%.
No, that will be an increase. The capital subsidy, which was earlier given only for 15%, now will be increased to 30%.
So investment on plant and machinery.
Then you see to 30%. And the limit for automatic approval of the subsidy at this rate will be 1 year per crore as per the 30 lakh. And such subsidies shall be applicable to the units in the private sector, joint sector, so and so. And there will be an empowered committee chaired by the chairman.
Yes.
So and so, so and so. So and so, so and so. Proposals which are eligible for subsidy higher than 30 crores will be placed before so and so.
Correct. Yes.
So you mean to say anything will come then?
Plant and machinery, my lord, even if you notice, AC line, my lord, transformer, all
No,
are
that is a different thing. Would anything come then if we go by this thing?
my lord,
Because you see, in the
I know.
judgment in Justice Goswami's case, it was clear. 3% was the interest subsidy to be given. Then they have said that only on the substantial expansion which is there, that 3% would be given. Then it was said that when the industrial policy says so, how can you whittle it down by way of a notification? That is what it was mentioned.
then my lord, the other judgments are there on the retrospective.
Hmm?
Other judgments are there on retrospective. The MRF, what I am, my lord, 2006, 8, there are 27.
What did he say? Which paragraph?
There are 27.
Para?
20.
Yes.
The provisions of Act or notice are always prospective in a person unless express language enters it otherwise. Making
Para
it
22.
That 27. In the list, I held a settled principle of interpretation that the of person is not to be intended unless intention is manifested by express words or necessary implication. There is a subordinate rule to the effect that effective word as action is not construed to have larger restrictive operation than the language and
So you mean to say that there has to be clear intention in the 2013, saying it to be retrospective, then only it could have been. Otherwise, it has to be used as prospective.
the next Malor case is 2008 13 SCC 1.
Yes. What did it say?
There are 21 and 30.
Yes.
Now, well said principle that doctrine of principle applies to the state. It will not suited with this water to consider prospective nature. When a policy decision is required to be given a retrospective operation, it must be stated so expressly or by necessary implication. The authority issuing such direction must have power to do so. The board having acted pursuant to the decision of the state would not have taken a decision which would be violative of the such decision.
Then
Then on policy, Malad, they can change it. Malad, that is on they can change the policy in public interest.
no, there is no quarrel with
No,
the changing
my
with the policy.
Yes.
They
Now,
can. But the question is whether the change of the policy will be deemed to be effective from 12. And in the meantime, if you have already taken steps,
Malad,
whether you will be entitled to the benefit of,
Malad, that is one of the
you have on the
before-
basis of the promise which was given as per 6, 1, 2, and 3, you have already
invested and
Now
submitted.
they have narrowed it down by reducing. Now, what do you say about that recent judgment as regards that 50% which was brought in? The uh, excise thing which was given, the benefit which was given out here was reduced by 50%. That judgment, I think, Hero Honda Corp, no,
Yes.
which
Yes,
matter went to,
Hero
from here,
Motor.
na? From here it went.
Yes, Hero Motor.
Wherein it says that can be done.
It can be done.
But was it retrospective?
Yeah, if yes, it was retrospective there also. It says that because there is a public policy involved and like reason for why they have done it that has been explicitly stated. So in that those cases,
But that is a change of policy there. In Hero Motor to also change of policy. I'm just testing Malad.
No, but was the policy made retrospective?
The policy was not developed. Malad, it says it further we noted that court has constantly held that when exemption granted earlier, it was done by subsequent notification based on a change of policy. Even in such case, doctrine of policy could not be invoked. It has been constantly held that where a change of policy is larger public interest.
Where is that judgment?
Malad, that last time I have submitted, I can just give it to you. Malad. This copy may be 7 to 17 paragraph.
And what are you referring to? This beta?
Mendelsohn Hotel, my lord. Mendelsohn Hotel, my lord, from paragraph 30 here, my lord. 12, 13, 19, 20, 23.
What is this?
Here, lord. That 12, my lord, they have quoted Motilal Court, my lord. Anglo Agency and others. 13 also they have quoted Motilal Court. Now, there are 19 my lord, that here.
Yes.
In fact, we must never forget that Dr. Punchmel is doctrine whose foundation is an unconscionable departure by one party from the subject matter assumption that which may in fact law, present or future, which should be adopted by the other party as a
There are 19, which page?
page, my lord, 782. In fact, we
yeah.
must never forget the doctrine of Procedural is a doctrine which foundation is that an unconscionable departure by one party from the subject matter of an assumption which may be in fact or law, present or future, which has been adopted by the other party as the basis of some course of conduct, act or omission, should not be allowed to pass muster. And the relief to be given in cases of involving doctrine of Procedural contains a degree of sensitivity, which would be ultimately render justice to the aggrieved party. The entire basis of this doctrine has been well put in the judgment of the Australian High Court in Constitution. The entire, if any portion has been quoted. Then
And-
there are 20 fellows.
This
About
is
the
Govind Prasad case.
yes, Govind Prasad, my lord. Govind Prasad, my lord, here para 11 and 12.
No, if it is said to be clarificated,
Well, it cannot be clarificatory, my lord. Here, Professor see, many important parts of the machinery has been included. Kilo, Upar. Well, I shall place that chart I have annexed, my lord. They are there, but- and even, my lord, if you'll also see in 2012 also, they have ST line, transformer, everything has been excluded in this item. Well, that is, even 2013 also that is included. They have excluded, my lord.
but that is not the case of tenure. Your case is on 2013.
13, my lord. So on the basis, my lord, they have come to this, my lord, in this item. My lord, everything, my lord, if you also see, my lord, that the transformer, main transformer, the electric line connection, everything has been excluded. That can be. Then Villa Corporation case is also there, my lord, 2020. There are 35, mainly 34.
But it is there.
My lord, this is a no, this is here, my lord.
And who issued the 2013 notification? Is it an office member?
It's like a, my lord, under secretary. Under secretary.
Huh?
Under secretary to go with it.
So if we hold that the 25 to 2013 would be prospective
My lord.
and it shall not apply to the petitioner who have or those petitioners who set up the industry earlier prior to that.
Submitted claim.
Yeah. No, who set up the industry prior to that
Prior to that. And submitted claim.
and whose claims are pending then would not apply. That is the thing which you want.
Well.
The rest they will do it thereafter.
Yes.
This is not for the court to look into.
No.
Anything else?
The judgments are there, but from the judgment.
You ask your Mr. H.K. Sharma, your learned, to give me what you call the paragraphs of whichever judgment you.
No, I have given the list also, my lord. In the list, my lord, there paragraphs are there.
You are referring to these, no?
Yes.
PTP, MRF, Kusunum, Monumental, Govind Prasad,
Yes.
State of UP, Sonia, and State of Jharkhand.
Yes.
What is the Jharkhand business?
Correct.
2023 TNS. That's the latest judge. That is the.
Then 23 one, I have only seen my lord submitted earlier.
Don't Mr. Taiwala, you are arguing for a matter of growth. Don't be stingy enough not to give me that again. You
Yes.
want me to search from this pile of papers?
No, I'm giving it again now. I'm coming.
Second appeal, I would not have troubled you, but not with you. And state of Jharkhand, which paragraph?
My lord,
Or just referred it?
I have referred, my lord, earlier, my lord, say I have not written, my lord, the backup.
Huh? Here also you have not given.
Yeah, backups are there.
No.
Those in the list, the backups are
No,
there.
no, state of Jharkhand, no paragraph.
No, that is the, my lord.
So you want this court to look into the entire thing?
I'm sorry, my lord. Because earlier I placed it, that is why, my lord.
Yes, anything else? Nothing.
No, my lord. That only thing, people often see how they have excluded that even ST line, my lord, transformer main line also excluded as in into item.
Yes, Mr.
Yes, Lord. Suppose that introduction of the comprehensive list of components of plant and machinery, which is required to be considered for eligibility and ineligibility of a subsidy, we have tried to justify in our affidavit. So we kindly come to page 101, paragraph 3D of our affidavit.
Yes.
May I read, madam?
Hmm.
The decision of introducing comprehensive list of components of plant and machinery to be considered eligible and ineligible for subsidy by the answering respondent is needed so that by specifying eligible components, the government can mitigate the risks of misuse or abuse of subsidy program. It helps prevent industry.
No, Mr.
My
Adhikari,
lord.
there is no doubt that this is in very good earnest you have done.
My lord.
There's
My
no
lord.
quarrel. But can you apply the same thing to those pending claims? That's the question. We are boiling down to a very short cap. We are not concerned with this. We like, we may, if you want, I can just put a certificate that yes, it has been done in very right earnest. But the question is whether you make it a retrospective in respect to those pending claims which they have taken. There was nothing mentioned because otherwise I would have understood. 6, 1, 2, and 3. There was something mentioned about the plant and machine. You are to deal with that. People may have invested accordingly. People may not have invested if you had made it to this, or may have invested, but they would not have taken or may have, just for example, they are going to get 30% as subsidy. They would not like to take the machine which is there of that amount because obviously I'm getting 30%. So the price of that machine, if I take a very good machine, it will be just 70% I have to pay. So these are things which the person would have not done if that is not there. This is in very right earnest, but did you do that retrospectively? If you have not done that retrospectively, then how do you take care of that? And from a reading of page 93 of the particular document, it does not show. It seems that there has been certain confusion going on because net fee was giving some benefits to somebody on the basis of the 6-1, earlier one. And therefore, it was a requirement for which there was an empowered committee. Empowered committee looked into it and came up with this. Now we set out, these are the things which are there. And you see the language which has been used out here. You see this, finally come to page 94.
Yeah.
Roman 4.
Yeah.
Based on the definition of PNM, you've got it?
Yeah.
Provided by in the scheme notification, subsequent clarifications and recommendations of the technical agency comprehensive list of components to be considered so and so under CCIS is enclosed as so and so. So it is subsequent to those clarifications or whatever maybe has been given. So they have given this. And what is the intention? Because there were certain things which were going on. Some departments were saying something else, some departments, and as such to come to a concrete amount, this is rightly done. There is no quarrel with that. But those who have invested on the basis of 6-1 earlier, 6, can you say that they are not entitled to or reduce it on the basis of this? Quick, long and short. No quarrel. You can very well. The promissory estoppel concept very well. But the promissory estoppel, Mr. Sahewala is that, you see, I have invested on the basis there. After investing, file my claim, everything done. Now the government comes up with a policy saying that look here, these are the eligible, which these are not. Why didn't the government earlier say that? Wasn't that amount to reducing what is there? Unless you say that there is a case question of fraud being there. This could not have been a part of the plant and machinery. Under no circumstances, even under 6, it could not have been. But there is a misuse being made. That's not the case.
But here, my lord, what we are trying to justify is, my lord, that since some irregularities were detected, my lord, and there was no uniformity.
No, there's no irregularity. Kindly see the language of the 94. What does it say? It doesn't say about irregularity. It says that there were some people were giving something, and
Yes.
therefore now we have decided that these will be the
Inconsistent methodology
adopted by various agents.
Yes, yes,
That is why we have come up with.
yes.
Now, wouldn't that be applied prospectively from 2013? Can you apply earlier for that? Because if you apply it, wouldn't the principle of promissory estoppel be hit? There's no quarrel you can take away. You see, if you see Hindu on the court or any other judgment, even if you go to any those judgments of Anglo-Afghan and all, one thing you will see that the government has no doubt the power to take away. But can the government take away which have been already given? If I remember correctly, you say earlier, but one thing you can do is by taking away statutory. That can be done because there cannot be an estoppel against the statute. You see, if I remember correctly, initially the
Cigarette case,
cigarette case, the tobacco cases. You see, when initially in the 1997, 24/12/1997, the first policy, the Northeast Industrial Policy was announced. They had Chapter 24. Chapter 24 pertains to tobacco. So what was happening? All these tobacco companies who were there, they came out here, started doing the business out here, and they were getting everything. Even all these big other things like pan masala, the tobacco, and all these things. Then the government came up with a notification. That was the notification of 8/7/99, if I remember. That notification was taken away and amending it that they would not get the benefit of these. Retrospectively taking away the benefit. There were very challenges. When the challenges were there, you could not take away retrospectively. That was going on. And there is a promissory estoppel we have set out. Then the government came up and amended it by the Finance Act. And thereby, all the challenges had to become nullified because there cannot be an estoppel against the state statute. So here it would be prospective. If it is prospective, how do you take care of it? Yes.
Then this is very clear that Lordship that there is nothing mentioned in the notification. There is nothing mentioned in the notification. The only thing is that Lordship, I mean, in application of retrospective and prospective, I mean, though they have started the process and they have filed the claim, when the claim was examined, at that point of time, this notification was there, very much there.
No.
When it was examined, the notification was there.
Examination means final. Examination, then the notification. You kindly
Yes,
see here.
I mean, when this field visit was done,
Hmm.
then this notification was done.
The application was filed when?
Lordship, Lordship may kindly take up.
Inquiry report
Yes, inquiry
is
report.
10/11/2012.
Yes.
Annexure 1 at page 147.
So the first verification was done on Lordship 30/11/2012. That was the first verification. At that point of time, this was not there.
But in the meantime, he has already set up his industry.
That's correct, Lordship. But on the face of a notification which has come to the state that you comply with this.
No, therefore, there is no quarrel with the proposition that the state has to give it because the state does not have the power to
Power.
interpret
Correct.
to that effect that whether it is there.
Correct.
Therefore, the only order which this court can address trust in favor of the petitioner is that that notification cannot be made applicable in respect to the claim of the petitioner, nothing more than that.
That's
And thereupon, what is to be ever is to be decided, that is it. Otherwise, there is nothing else.
correct. There is nothing in the case. So, I mean,
Otherwise, there is nothing else. As regards all these things,
The
whether
response-
Hooper and all these things
Yeah,
will
those
come or
are-
not, these are nothing.
those Lordship cannot see one.
I am not going to look into it. I am more into a civil bench, one judge now. I am into.
So Lordship has to decide whether this can be done retrospectively or prospectively. The only thing is that because of certain.
And if that notification, they came up with a notice. This is more like a.
It's a
communication.
clarification. It's a notification, Lordship.
It's not a notification. It's a communication.
No, it's a communication. Yes,
It's a communication, not a notification.
it's a communication.
See, by way of a communication, you have just clarified, you mentioned out there, these are the things we are making it now. So this will apply prospectively, but you cannot take away what is notification.
I understood.
That is the problem.
That Lordship.
No. I don't have any CAVs. Let me have one CAV.
The board should not be blank.
Huh?
That column should not be blank. At least one should be there.
Even all second appeals, my lord, you'll also.
No, I don't have. Because I'm making it only CAV because of the fact that otherwise it will hurt the second appeal bench.
Right.
That is the only thing.
That's the.
Can't help it otherwise.
And
because-
I don't have anything to argue on this also. Nothing is there.
Now, all the other things as regards the Hoopers and all, you will have to decide as to how it is.
Yes,
If
yes,
he's
no.
agreed by that, then I think there's the appeal
No,
provisions,
No,
whatever may
Lordship,
be.
in fact, Lordship, 2013 added certain more things. Electrical equipments and all, those things are not there. Those have been added. But we are within the frame of electrical equipment, also certain things were excluded. That is the thing. Those have been excluded.
Let me deliver it.
Obliged.
Azizur Rahman Laskar, he died.
Let me hear him. If the appeal can be dismissed, not necessary to substitute.
My lord, one problem is there. My name is not there, my lord.
Not necessary. I'm not going to hear you. If the appeal can succeed, then I'm going to
Well.
allow. Because this is a 2006 matter.
6 my lord.
And earlier, if I remember, I heard this matter. Matter got adjourned.
Yes.
And I've asked him to produce a type copy of the Bainama. Whether the suit for specific performance of a contract, where the impute judgments and decree have been passed is barred by limitation. Where is the Bainama?
Mine.
let's see how
Well,
the court have taken, the trial court have done this.
my lord,
Bainama is dated
Bainama is
33
dated
392. When did you file the suit?
and suit file 7296.
Huh?
7290.
7 to
90.
90?
6.
96.
Well, yes.
7
After
to
3 years.
1996 suit file.
File.
Bainama dated
3390.
3392. Okay, Bainama. Okay.
I submitted, my lord, that
In course of a
Okay,
learned
like-
counsel appear mainly
there is no pleading in the suit, my lord, to exempt the delay.
not necessary. In course of the argument, learned counsel appear and challenge the teacher of the learned counsel. And what was this title suit 96/92?
That was filed by the present appellant against for declaring this Bainama as the legal. And that suit he has filed it obvious counterclaim, and counterclaim was returned with the direction.
You are the plaintiff.
I am the in that suit I also the plaintiff challenging the Bainama, and in that suit he appeared after receiving the notice and filed counterclaim. His counterclaim was returned with a direction to take step. He abandoned to take the step.
Understood. Understood. Title suit 96/. This suit is what is the number of this suit?
My lord, their suit
This is 96.
Yes.
The earlier suit was 92. Who filed?
92. We filed.
You filed title suit 92.
90.
TS 92, 96/92.
Well.
For?
For challenging the Bainama.
And you have then filed another suit for specific performance.
No. The respondent here, my lord, he has filed the suit. My lord.
Of the
Yes.
Bainama, challenging the Bainama. When?
He has filed the suit for execution of the Bainama, for execution of this held it in terms of the Bainama. That is the defendant's respondent case is appeal. And we filed earlier to that the defendant in the present suit, he has earlier filed a title suit of 1992 challenging the Bainama.
So it was held within the period of limitation.
Yes. By, my lord, giving benefit of Bonafide proceeding. They are giving benefit of Bonafide proceeding.
Of what proceedings?
Bonafide proceeding.
Okay, then
Because in earlier suit which was filed by us, in that case he filed a counterclaim. That counterclaim was returned with the direction to take step. My lord, he has abandoned that proceeding. My lord, no step was taken pursuant to that order and filed a phase 2. So giving benefit of Bonafide proceeding of that counterclaim is not as per law. That cannot be met. He has abandoned, and that is their pleading. I have given one cross part of the evidence of the plaintiff witness one. He has admitted that I have not submitted counterclaim despite having order to file counterclaim in the suit instituted by the defendant. So how he can be given, my lord, the benefit of Bonafide proceeding?
in fact, you have a case not on that aspect. You have a case on the basis you want the suit to be barred by limiting.
Yes.
See,
No pleading as such in this plain. No pleading for exemption under order 7.
no, let us not go into that. We can go into the other issue. That when it is said that within 2 months he shall obtain the permission. Did he obtain the permission? Did he obtain the permission?
My lord,
No. If he has not obtained the permission, you are the person who has to sell it. If you have not obtained the permission within these 2 months,
my lord, I have challenged the Binama because he has manipulated the Binama.
okay.
Therefore, we have not.
But you did not obtain the permission.
That is.
Say this judgment, we have a case in this case of this judgment. In this case, Patechanji was what he said is this. That was a case under Article 54. And Order 7, Rule 11 was invoked for it. Here it says, the fact that the plaintiff were put in possession of the property agreed to be sold on the date of the agreement itself would not make any difference with regard to the limitation of filing the suit for specific performance. In fact, both the courts below have rightly held that Article 54 of the Limitation Act does not have any difference between the case where possession of the property has been delivered in part performance of the agreement or otherwise. In the same way, the courts below have concurrently held that if any permission is to be obtained prior to performance completion of the contract, the mere fact that the defendants have not obtained the said permission would not lead to the inference that no cause of action for the suit, filing of the suit for specific performance would arise. Meaning thereby, the specific performance were twofold. First, he will obtain the permission within 2 months and then execute the deed of sale. If the first part is taken, if he have not applied for the permission at all, so under such circumstances, if he did not apply within these 2 months, his period of limitation will start from there. On 3/3/1992 was the date. So his period with limitation would start from 3/5/1992.
Then also, my lord, part filing.
If it is filed under 3/5/1992, then he had to file he filed a counterclaim. When did he file the counterclaim? 93.
My lord, he filed counterclaim.
93.
90. Yes, my lord. 31. Uh, 4593.
So he filed it 3593. Now 2 months is 4593. He filed it within time. Suit for specific performance. A counterclaim is like a suit for specific performance.
Right.
So he filed it within time. Then the plaint was returned.
Returned with the direction to take stay. But he has not taken stay. Rather, he abandoned. That is his admission.
Counterclaim was for what?
Counterclaim, my lord, for
Specific performance.
specific performance.
No. Your counterclaim was you
No.
filed. They filed the counterclaim
Their
for
counterclaim in
for
my
neg- for the bynumber to be illegal.
I filed suit for declaring bynum as illegal, and in that case, he have filed the counterclaim.
For specific performance.
Specific performance.
So he filed it within time. If we see 35,
My lord, it's
92 is the, no.
4593.
So that is within 1 year. He filed it.
Yes, that is one year.
Then it was returned when?
It was returned, my lord, 459. Returned on 4593 on the same day.
Huh?
4593 it was returned.
No. It was returned on 47.
Actually, my lord,
4593.
order was passed on 4593 as per the notes available in the record, my lord. What I have found, my lord, the counterclaim was ordered on, my lord. Return order was passed on 4593, but actually the same was returned on 15/11/1995.
Why?
I don't know, my lord.
No. Order, whenever the order is passed, that is it.
That is
Yes,
sufficient.
Now 4593, if it was returned,
Yeah.
then you filed a suit
I filed
in 96.
96.
Then only this period from 35,
Yes.
93, on that day, only 1 day is there. Only you get a benefit of 1 day. If it is 1 day only, then earlier period has to be taken 1 year. And then you have to, it is barred by limitation.
Probably, my lord, the court has not returned the plane.
Let's see the
Counterclaim,
record.
it will be clarified from the record, my lord. And in fact, the 1992 suit, which was filed by
Here it has been held now. Why should we go into all other things? 4593.
Yes.
Date of filing of the claim by so and so. In the instant case, as per the provisions of IMA section from 92, 92, the date of return of the counterclaim has to be excluded from the period. 93, it was returned on. Counterclaim was returned on when? 4593. So the date on which he has filed, it was returned. So it has to be filed within that 1 year has already elapsed. Then how could you file into 96?
but from the notes available in the record, I have found that it was, although the counterclaim was returned by the court, I had ordered it 4593, yet actually the same was returned on 15/11/1995.
There cannot be the
When there
question
is
of
the order,
return.
it
There
is
will be
that-
only one order. If it is return. Whether here it says, in the first appellate court, it is an admitted position that the present plaintiff, who is the defendant in the suit of so and so, filed WS along with counterclaim on 31/8/92. He filed on 31/8/92. And the trial court wide ordered it at 4593 return. So he gets the benefit from 31/8/92 to 4593, he gets the benefit. But then also it is beyond the limitation. Because his period will start from 4/5/1992. 4/5/1992, his period will start. So from 4/5/1992, 592 to 38/92, this is the period which is to be taken. And then from 5/5/93 to the date on which the suit was filed. Suit was filed when? 96 something.
90,
7 to 96.
7 to 9.
7 to 96. Does the period, is it within the period? Four 592 to Iman, how much days will be?
4, 5, 4, 5, 9.
5593
7.
to 5596.
It will be about 3 years, 9 months.
Hmm?
3 years, 9 months.
How?
92
No, 93.
to 96.
No, 5593.
4, 5,
5,
5593 to 7 to 96. How much?
It will be
2 years.
3, 5, 9. 3, 5, 9. 3, 5, 9. Huh? Yes, 3, 5, 90. 3, 5, 82.
It will be, my lord, 2 years.
No, 3, more than 3 years.
No.
Limitation will count from 4, 5, 90, 5, 5, 93.
My lord, it is 3, from 3, 5, 92 to 7 to 96. Adding 2 months to 3, 3, 92 will be 3, 5, 90. Will be 3 years, 9 months, 9 months. Date of Panama is 3, 3, 92. So adding 2 months, it will be 3, 5, 90. And it was filed on 7 to 90.
It is 1008 days. From 5593 to 7 to 96, 1008 days. And from 4592 to 3 years, 29 days. Total days is 1126. From 4592 to 3892. So his cause of action for specific performance starts from 45 because 3392 was the date, 2 months was given.
2 months.
So 4592 the time starts and ends on 3892 because he filed a counterclaim on 31. Then from 5593 to 72, we'll make it 62. It is totally 1125 days. It is 3 years, 28 days. Okay, I think now this is a case where we need to complete the sole response. Mr.
MK Sharma.
M.K. Sharma appearing on behalf of the Learned Counsel, Mr. M.K. Sharma, who was earlier representing the respondent, sole respondent.
Not representing my lord.
Hmm?
Not representing my lord.
Earlier,
Not my lord. My senior was there, Mr. A.B. Chaudhary, so the senior counsel was there.
but you are now there.
He is also appearing.
One or two occasions I have appeared, my lord. In fact,
My lord, all along he is appearing.
Mr. M.K. Sharma, the Learned Counsel.
few occasions, yes, my lord, I have appeared on behalf of my senior counsel. Senior.
Okay. Submits on instructions that there is nobody. A.B. Chaudhary to not there. Soumitra De, S.A. Chaudhary, nobody is there.
No, SSJ, my lord, also, I think he also died, my lord.
Soumitra De,
Yes, my lord, he also died, my lord.
then how are you representing anybody?
And S.A. S. Chaudhary, she left profession, my lord. She was the daughter of the senior counsel, my lord. After marriage, she left the profession.
But you have received many steps on behalf of
Yes, my lord. While
Mr. M.K. Sharma, the Learned Counsel, who was earlier representing the respondent, submits that the said respondent expired on
My lord, that is not clear. I have asked them to send the next of kin certificate. In the next of kin certificate, the name of the legal year as well as date of death is there. My lord, they have
that sole respondent expired about a year back,
about a year back.
where, as he was telephonically informed. When?
My lord, on in the month of March, my lord.
In the month of March 2024. He has asked the said respondent to provide him the next of kin certificate as well as the date of death. You have got the next of,
My lord, this was issued by the Gaon Panchayat, my lord, but no date of death was mentioned.
as well as the date of death. So this court fixes the matter again on 10th of May. Possible to get it. Only the details, nothing more.
Yes, my lord. I will ask them.
On 13th of May. 13th of May.
13th.
On which date the Learned Counsel shall apprise this court as regards the date of death of the sole respondent, as well as also as to whether he has any legal representatives and their names. Taking into account the above, the matter stands adjourned to be listed again on that.
My lord, may I pay for some modification of the date?
What?
1 day ahead or 1 day later?
No, on 13th.
Uh-huh.
Ask him to, I'm fixing it on a non-miscellaneous day, on a miscellaneous day. On that day, hearing won't happen. Your person, he will intimate.
Right.
Then you have to take steps. Nah?
Right.
How can we, this court proceed with it? Now taking into account that it is 3 years, 29 days, suit has to be barred.
My lord. Yes, my lord.
So
I
that
am-
is the
I'm
reason.
paying for only modification. It may be 1 day ahead, my lord. Not
Make anybody will can do it.
my
Only that.
my lord.
Ask your junior to be
My
present.
lord.
Lord, you should be happy. You should be happy, my lord.
Why?
My lord. Prima facie, he has a good case, my lord.
I made that calculation. Yes, you take this and give it to me on the next page.
I'll-
I may forget
I'm
again.
highly obliged, lord.
Obliged, your lord.
And that judgment, Fateh that judgment reported in, you take this, 2015 8 SCC 390. Yes, what is this?
Senior is the next and pass for
Who
the
is your senior?
KR party. The KR party.
Don't worry, you argue. Whether the suit property has fallen within the tribal belt and the plaintiff can acquire any right, title, and interest over the same, whether the finding or reversing here is contradictory. Number one, whether it is tribal belt,
Land is under tribal. Yes, that is under tribal.
then
Then lordship, both are under tribal belt, lordship. Both appellant and respondent are residing under the tribal belt, lordship, and they are tribal, lordship.
then there's no problem.
No.
There's no bar. Both are tribal.
Yes, yes.
So what is the problem?
Yes, yes. So this substantial question of law, lordship, I don't know why that is framed, lordship.
Under what provision?
It's taken up.
No, let me dictate the front portion. Let him come. By the time he comes, I will decide that. Don't. These matters can't be delayed. Once I delay this matter will go away and somebody else, some other matter. This court doesn't have the luxury of time. Hello, Lehok. This is an appeal under section 100. Don't worry. Yes, your senior can still mold the court by the time it finishes. Okay? I'm just dictating it, starting in the dictation. Yes. Because I have to write anyway, this way or that way, I have to write on this level. This court, by an order dated, this is an appeal against the, this is an appeal under section 100 against the judgment and decree dated the judgment and decree.
Page 65, appellate judgment.
Judgment
14
and
May.
decree
2007.
dated 14
May.
5 2007 passed by the in title appeal number 7 oblique 2006 passed by the court of the civil judge Lakhimpur, not Lakhimpur, hereinafter referred to as the first appellate court, whereby the learned first appellate court interfered with the judgment and decree dated 25/10/2006 in title suit number 12 oblique 2004. Passed by the court of the learned Munsif number 1, not Lakhimpur, hereinafter referred to as the learned trial court. This court, by an order dated 24/3/2008, admitted the instant appeal by formulating two substantial questions of law, which reads as under 1 and 2. For deciding as to whether the said two substantial questions of law are involved in the instant appeal, this court finds it relevant to take note of that the respondents herein as plaintiff have instituted a suit seeking specific performance of an agreement dated 17/9/84 semicolon for declaration of right, title, and interest over the suit land in favor of the plaintiff, for recovery of khas possession, and for permanent injunction. The brief facts of the said suit, which have been registered and numbered as title suit number 12/2004, was that one Joy Singh Gore, by a unregistered sale deed handed delivery or possession of the land to the defendant number one subsequent thereto, the defendant number one got his name recorded in the record of rights. The defendant number one, as alleged, had entered into an agreement with one Dilip Kumar Seal, who was the son of the plaintiff number one and the husband and father of the rest of the plaintiffs, by an agreement dated 17/9/84 for sale of the suit land at a total consideration of rupees 8,000, of which rupees 6,970 was paid to the defendant number one. Subsequent thereto, the defendant number one executed another agreement dated 21/2/89 whereby the consideration for the sale of the land was increased from 8,000 to 9,000. And it was agreed that the sale would be made once the no objection certificate was received. It is also alleged that the defendant number one did not execute the deed of sale, but rather executed sworn an affidavit, read a sworn an affidavit. And handed over possession to the plaintiff number one with an assurance that the registered sale deed would be executed. Thereupon, the defendant went to July subsequent thereto, the defendant number one tried to create obstructions to the possession of the plaintiff, for which the plaintiffs were compelled to institute the proceedings under section 145, which was registered and numbered as Miss Case number 47/2001. It is under such circumstances the plaintiff instituted the suit seeking the relief as sought for. The defendants thereupon submitted a joint written statement along with a counterclaim. Stating inter alia that the plaintiff failed to perform their part of the contract, and as such the suit was not maintainable. It was also stated that the said suit had no legal force and the claim was time barred, that too on the basis of a fake document. Accordingly, the defendants not only sought for dismissal of the suit, but sought for a decree that the counterclaimant the decree that for declaration that the plaintiffs have had no right, title, and interest and possession over the suit land, and for confirmation of the possession of the defendants, for declaration that the so-called sale deed dated 10/18/1/2001 and the affidavit dated 18/1/2001 are not enforceable against the defendants, and for permanent injunction. On the basis of the pleading,
Lordship, I have filed a written statement against the counterclaim also. That is on record.
the plaintiff thereupon filed a written statement against the counterclaim, reiterating the stand taken in the plaint
Yes, yes.
and sought for dismissal of the counterclaim. The learned trial court, on the basis of the pleading, framed as many as 11 issues. On behalf of the plaintiff, there were 7 witnesses whose evidence was reduced, and the plaintiff exhibited 8 documents whereas the defendant examined 3 witnesses and exhibited also 7 documents. The learned trial court, by the judgment and decree dated 25/10/2006, dismissed the suit and decreed the counterclaim of the plaintiff, of the defendants, stating in thereby decreeing that the plaintiff defendants have a right, title, and interest and possession over the suit land, comma, semicolon, thereby confirming the possession of the suit land in favor of the plaintiff defendants. It was also held that the so-called sale deed dated 18/1/2001 and the affidavit dated 18/1/2006, 6 or 1, both are 1, nah?
1.
Are not enforceable against the defendants, and the plaintiffs were permanently restrained from entering into the suit land and to engage people to disturb the possession of the defendants. Being aggrieved, an appeal was filed by the plaintiffs, which was registered and numbered as Title Appeal Number 7/2006. The learned First Appellate Court reversed the judgment of the learned trial court, thereby decreeing the suit in favor of the plaintiffs and dismissing the counterclaim of the defendants. It was further decreed by the First Appellate Court that the defendant shall execute the sale deed in respect of the suit land measuring 8 bighas 2 kathas in favor of the plaintiffs within 90 days from the date of passing of this order, and the plaintiff shall make a payment of rupees 1,030 to the defendants within 1 month from the date of passing of this order. Being agreed, the instant appeal has been filed by the instant appeal has been filed by the defendants, and this court had admitted the appeal by formulating the substantial questions of law which have been already above noted. Yes, Mr. Padgiri, we will look into this at 2 to make a submission.
In the tribal bell, the plaintiff respondent can acquire any right, title, and interest over the same. As because my lord, the chapter 10 of the land rehabilitation, there is a bar, my lord, to civil court to exhibit the term. The dispute arises, my lord, regarding my lord, permanent residence of the permanent tenant, my lord. And on this regard, my lord, issue number 7, my lord, kindly see issue number 7, my lord. And discussion of the trial court, my lord, page 20 of the judgment. Paragraph 19. May I read, my lord? The plaintiff, my lord, exhibited 2 documents, my lord, regarding permanent residence. One certificate issued from the circle officer and another Jamabundi copy, wherein, my lord, the name of the plaintiff number 1 shown as on that certificate Mohendra Napit, son of late Sukhdev Napit. And Jamabundi court copy also, my lord, his name reflected as Mohendra Napit. Therefore, my lord, the landed trial court, my lord, observe, my lord, find that, my lord, that document, my lord, has not, my lord, relied regarding permanent residence of the plaintiff, my lord. Paragraph 20. The plaintiff number 2, 3, 4, and 5, 6 have filed any document or oral evidence that they are the permanent residents of tribal law. The basis of that issue, my lord, the
No, tell me, Mr. Padgiri, whether there is a bar for transferring. There is no bar for transferring, but subject to the permission.
167 then revenue regulation.
Did it?
One 160 bar of jurisdiction. No civil court shall exercise jurisdiction in any of the matters covered by this chapter.
No, that is different. That has nothing to do with that. 167 is different. This is a suit for specific performance.
My lord.
So suit for specific performance, that has nothing to do. But I am on this thing. That the bar which is there is subject to permission.
There is a provision, my lord. 3. Transfer of land within tribal belt area.
Now he is not a tribal.
No. Still, my lord.
No.
Not only, my lord, schedule pass.
And the document on which he is saying that he is Napit.
Napit. And son of my lord, Napit. But wherein, my lord, in my lord, plain, my lord, he stated, my lord, his name is Mohendra Hazam, son of late Gopi Hazam. Gopi Singh.
Mohendra Hazam.
Son of
Mohendra Hazam is nothing to do. Who is Mohendra Hazam?
It is my lord, plaintiff number 1, my lord.
Plaintiff number 1 is the father
Father
of
of the my lord,
Seal.
Dilip Soikia.
Dilip Seal.
Dilip no,
Seal.
my lord. I am
Plaintiff number 1 is the father of the Dilip Seal.
no, my lord. I am the Vijayalal Gaur.
Huh?
Vijayalal Gaur. And
I am
Mohendra,
not on that. You are Vijoylal Gore.
my lord,
I am not on that. I am saying the plaintiff. You are the defendant.
defendant, my
Where you are saying you are a plaintiff? Plaintiff's father's name is Mohendra Hazam,
lord.
alias Seal,
Seal.
and his sons has entered into the agreement.
Dilip Seal.
Dilip Seal.
But-
Now, Dilip Seal and Aya, is there any document to show that they are permanent residents of that area?
My lord. But he already died, my lord. He cannot show, my lord.
Now, what do you say about 164.2? The proviso to section 164.2 provided further that no such landholder shall transfer his land in the belt or block to any person who is a permanent resident in that belt or block and who does not belong to a class of demand. Class or people notified under one, except with the previous permission of the Deputy Commissioner, provided also that in granting such permission shall have due regard to the interest of the people belonging to the classes notified under that section.
Permission from the
So it is not an absolute bar, but subject to the permission from the Deputy Commissioner. So what is the problem?
without permission, but the
Permission
civil
is
code can-
different.
but,
That the court can very well make it, whatever may be, that will be subject to the permission in terms of the Deputy Commissioner, which he has to take. Merely because a decree has been passed, that would not amount to a permission. The permission has to be given by the Deputy Commissioner with due regard to keeping in mind the proviso, the second proviso to section 164.
my lord, to any person who is not a permanent resident in their belt or
And he has failed to show that. And the first appellate court did not look into that aspect at all. Said that he is a permanent resident.
first,
First appellate court, you see how it dealt with.
for my lord, kindly see, my lord.
Page 75. Plaintiffs have claimed that he is a permanent resident and the defendants also belong to the same place. So this question of residence has nothing to do. This is absolutely wrong.
Absolutely wrong, my lord.
How do you take care of this?
Issue 7. Issue number 7.
75.
Page number 7. No, I am that locality, but yes, that is not reflected, my lord, not deciding, not giving any reasoning. That is true, my lord. But my lord, we are belong to that area, and I am permanent resident of that. That is, my lord, probably that exhibit 7 was produced. My lord. Exhibit 7.
Exhibit 7 does not contain his name.
That's father's name. Mohendra, yes, Napit, my lord, they are originally, my lord, they are Napit. Probably.
So then you should have written out the Napit. Why did you write Hazam? Hazam and Napit means the same, but how do you take care of that?
His other name also different.
Father's name is Mahonda Hazong and Ilyas Sil.
Sukhdev Napit.
Sukhdev Sil.
How do you take care of that?
That, my lord, you lordship kindly see.
When the trial court, having dealt with that issue, have come to a fact-finding inquiry, fact-finding, which the first appellate court did not at all consider.
That, my lord, yes, I have also seen that issue number 7 is, my lord, there is no without giving any reasoning.
No, not here, but there also, the trial court duly looked into Exhibit 7
My lord.
and came to a categorical finding of fact. If the court had to reverse it, the court had to come to an opinion.
Yes, my lord, by giving a proper.
Which the trial court did, the first appellate court did not. That is one. Secondly, the fact that you have not mentioned anywhere that you are also Napit. How do you take care of that situation that I am also known as Napit without that statement anywhere?
No, in plain there is no statement.
The trial court was right in finding with 7. Therefore, the substantial question of law arises.
So, my lord, regarding whether it is a sellable or land or that will be, my lord, deputy commissioner will look into. But, my lord, regarding, my lord, performance, my lord, your lordship is.
Performance is okay. But if it is, the land cannot be transferred because there is a complete bar under 164A.
Yes, my lord, I have seen 164, but that will be.
164 is only permission. See, 164 only pertains to permission. That there is a permission can be granted to with the deputy commissioner. But how do you take care of 164A unless there is a finding of fact in your favor that you are a permanent resident
of
there?
that locality.
So the bar under 164A will duly apply. It's a statutory bar.
That is good. So far, my lord, that question will be, my lord.
Very pertinent. Because there is an absolute bar under 164A. You will come under 164 provided there is a finding. Yes. Once there is a finding of fact. Now, if there was a finding of fact by the first appellate court, yes, this person concerned could have got it out there. There is nothing mentioned out there. This is absolutely shirking its responsibility. Paragraph 15 of Santosh Hazare has been flouted by the first appellate court, right, left, and center. Chalo. देखो. The first substantial, this court have duly heard Mr. K.R. Padgiri, the learned counsel, appearing on behalf of the appellant, and Mr. T.J. Mohanto, the learned senior counsel, assisted by Ms. P. Bhattacharjee, appearing on behalf of the respondent. The first substantial and have given due consideration to their respective submissions. The first substantial question of law pertains to as to whether the suit property having fallen within the tribal belt, the plaintiff oblique the respondent herein can acquire any right, title, and interest over the same. At this stage, this court finds it very pertinent to take note of that this very aspect was duly taken. This particular plea was duly taken in the written statement filed by the defendant, at more particularly at paragraph number 4. So, on the basis thereof, issue number 7 was issued framed. The learned trial court while deciding the issue number 7, categorically came to an opinion that Exhibit 7, which was produced, does not contain the name of the plaintiff number 1, on the other hand, number 1. At this stage, it is very pertinent to mention that in the name of the plaintiff number 1 is Mohendra Hazam alias Seal, son of late Gopi Seal alias Hazam. Whereas in Exhibit 7, which was produced, the name was shown as Mohendra Napit, son of late Sukhdev Napit. On the basis of the said categorical finding of fact, the learned trial court had disregarded Exhibit 7 and taking into account the provisions of Section 164 and 164A of the Assam Land and Revenue Regulation 1886, decided the said issue number 7 against the plaintiff. This court have duly taken note of the judgment of the first appellate court and the manner in which issue number 7 was dealt with. In the opinion of this court, the learned first appellate court did not have decided the said issue in a perfunctory manner by shirking itself with the responsibility which is endowed upon it, being the last court of facts and law. This court now finds it very pertinent to take note of the judgment of the Supreme Court in the case of Santosh Hazare versus Purushottam Tiwari, reported in 2001 3 SEC Tibata. And more particularly, versus Purushottam Tiwari, reported in 2001 3 SEC 179. And more particularly, to paragraph 15, wherein the Supreme Court had categorically delineated the role of the first appellate court. Paragraph 15 of the said judgment being relevant is reproduced herein under. From a perusal of the above paragraph, above settled position of law, it would be seen that while writing a judgment of reversal, the appellate court must remain conscious of two principles. Firstly, the finding of fact based on conflicting evidence arrived at by the trial court must weigh with the appellate court, more so when the finding of facts are based on oral evidence recorded by the same presiding judge who authors the judgment. And secondly, while reversing a finding of fact, the appellate court must come into close quarters with the reasoning assigned by the trial court and then assign its own reasons for arriving at a different finding. In the instant case, it would be seen that the learned first appellate court did not at all decide the said appeal, and more particularly issue number 7, which was vital in the said manner. In the backdrop of the above, if this court now takes up section 164 of the Assam Land and Revenue Rules, a regulation of 1886. Of the regulations of 1886, it will be seen that a settlement holder other than a landholder shall have no right in the land held by him beyond such seen that there is a bar of acquisition in a belt or a block to any person not belonging to a class notified under section 160 or to any person who is not a permanent resident in that belt or block. The plaintiff herein in view of the specific plea being taken in paragraph number 4 of the written statement was had the burden to prove that a plaintiff either belonged to the class of people notified under sections 160 or was a permanent resident in that belt or block to get a decree in its favor. However, however, from the discussions so made by the learned trial court in paragraph while deciding issue number 7, it is seen that the plaintiff failed to do so. And these findings of fact which have been arrived at on the basis of evidence have not been reversed in a manner in which it ought to have been done by the learned first appellate court. This court further finds it very pertinent to take note of section 164A of the Act Regulations of 1886, which completely bars acquisition of land which is in contravention of the provisions of chapter 10 of the Act of the Rules Regulations of 1886. And there cannot be any acquisition of any right or title in that land by any length of possession, whether adverse or not. Under such circumstances, this court is of the opinion that the substantial question of law, the first substantial question of law, so formulate duly, is involved in the instant appeal. Inasmuch as the decision so made in the said substantial question of law, in that question of law, would alter the course of the proceedings. Next. As regards the second substantial question of law, this court is of the opinion that the said substantial question of law, that same is not a substantial question of law involved in the instant appeal, inasmuch as the said substantial question of law so formulated is too vague. Accordingly, this court is of the opinion that the second substantial question of law is not involved in the appeal. Consequently, in view of the first substantial question of law having been involved, the instant appeal is allowed, thereby setting aside the judgment and decree passed by the learned first appellate court, dated so-and-so, entitled appeal number so-and-so, and restoring the judgment and decree passed by the learned first trial, dated judgment and decree dated so-and-so, passed by the learned trial court. Next. This court quantifies the cost of the instant appeal at, when was it filed? 2008. At 15,000, 20,000. At 20,000. In addition to that, the plaintiff, the appellant who is the plaintiff in the suit, shall be entitled to cost throughout. The registry shall return the LCR, transmit the LCR to the court. All right.
I tried to find out three of these judgments decided in 1975, but these are not, my lord, these three judgments, but we are unable to find it out because these are, at that time, GLR has not been published, and also not computer, I am not getting three of these judgments, very important judgment, but what they, because these are the three judgments, my lord, they have produced before the line of trial court, they mentioned, but not discussed. I am unable to get in 73, man. Second appeal of 1973.
What does it say?
No, but that's why actually I am unable to.
Your problem arises with the first appellate court judgment.
Yes, that's true, my lord. That para 7.
If there was some finding.
Issue number 7, my lord. Yes, I am also not satisfied in 4 line, my lord. While reversing will be very cautious. While reversing. Yes, trial court very elaborately discussed, but while reversing it, you have not written any 2 or 3 line, only 2 or 3 line. That's very difficult. Nothing to define, my lord.
Yes, madam. I gave you chance.
I have gone through the LCR lordship. In the second case lordship, there is a lease deed lordship.
Huh?
There is a lease deed, 99 years of lease was there by the Bharat Samiti lordship, original company, in favor of 7 persons. And thereafter lordship, that lease deed was executed by the Bharat Samiti, and that part is excluded while selling the other parts of the company lordship.
Now, first item is which one? RSA
Lordship 160 of
160. Let us first look into 160 because both will be separate judgment.
The earlier cases were also lordship dismissed only on this ground that they have exhibited their purchase deed exhibit 1 lordship. There is no mention of DAG number 70 and 5 on the lordship. And moreover, one thing is there, lordship, Bharat Samiti sold the tea lands to the Kalinagar tea estate. There it is clearly mentioned that excluding the lease deed areas, lordship. So that was not exhibited.
Now, whether you have exhibited that this area was the lease deed area,
Lease deed was exhibited in the next item, lordship.
I'm not concerned with that.
Lordship.
I'm concerned with the first.
In this case, that was not exhibited. In this case, their DAG number is 70, lordship. And their case is that DAG number 70, part of DAG number 70 was made sealing land, but this part of 70 area which we are possessing, lordship, these are the excess land of DAG number 70 that was not made sealing.
You say that you have purchased from somebody.
Yes, lordship.
Now, whether that purchase which was made
Lord.
was made from, did you produce the title of that person?
No, Lord.
Then,
but it is plaintiff's case, lordship. They ought to have.
plaintiff will produce the documents and that DW4K makes it clear.
That was not lordship proved, only exhibited. Exhibit 1 was only exhibited, lordship.
Understood, but DW4 makes it very clear that that is the land.
DW4 said, lordship, some lands were made sealing surplus from DAG number 70, and there are some excess land also. Those were not demarcated.
But the question is, the DW4 also categorically says that although those lands were taken over, but lands have never been surrendered. Isn't that the submission, the categorical say of the DW4?
Lordship, that I have gone through, but lordship, the DW4 also stated that there are some excess land in DAG number 70.
Understood.
Which were not.
Madam, how does the excess land happen? Tell me. Excess land happens that after the fixation of the holding which is being made under section 5, there is some excess land which is being found out. Now, this excess land has to be taken away by the government. But this has to be also surrendered. They have not surrendered it till date. Then how did you get the title over the land?
Lordship, in the next case, it was
Next, we will not come to next. First is first. We will go into next. First is this.
1976, there
First is one RSA 160.
Lordship, in this case only I have exhibited my purchase deeds, lordship.
160.
Yes, lordship.
And there you have purchased from somebody who isn't there, whose title is not shown.
But lordship, the plaintiff's case only basing on the exhibit 1, and on that exhibit 1 already, lordship, negated by the High Court and the Supreme Court also, that this deed does not include those lands, lordship. Only on the basis of this.
High Court and Supreme Court has done it, let it be done. Here also, this High Court will do it. I'm also a High Court. I will also do it, then let it go to Supreme Court. Let the Supreme Court overturn it. Don't worry with that. That I will take care of.
That much only I have seen, lordship, in the second.
Yeah, I'll take it. Okay. Record RSA 160. This is an appeal under section 100 of the Code of Civil Procedure 1908, challenging the judgment and decree dated 30/7/2007, passed by the learned Civil Judge Karimganj, hereinafter referred to as the First Appellate Court, entitled Appeal number 27/2003, thereby dismissing the appeal and affirming the judgment and decree dated 23/12/2002, passed by the learned Civil Judge, Junior Division number 3 at Karimganj, hereinafter referred to as the Trial Court, in title suit number 37/2001. This court, by an order dated 27/8/2008, admitted the instant appeal by formulating two substantial questions of law, which reads as under. Next. As to whether, in order to ascertain as to whether the two substantial questions of law which have been formulated are duly involved in the instant appeal, this court finds it very relevant to take note of the brief facts leading to the filing of the instant appeal. From the materials on record, it reveals that a plaintiff is a company. Plaintiff number one is a company registered under the provisions of the Companies Act 1954 and having its registered. And the plaintiff number two is the manager of the tea state belonging to the plaintiff company, namely Kalinagar Tea State, situated at P.O. Kalinagar Tea State in the district of Karimganj. It is a case of the plaintiff that a partnership firm, namely M.S. Guttu and Company, had purchased the Kalinagar Tea State from one Sri Ram Tea Company, a transferee of Bharat Samiti Limited, by the deed of sale bearing deed number 13th March 1974. Subsequent thereto, the assets and liabilities of the aforesaid partnership firm were transferred to the company, namely the plaintiff company, and which formed and constituted assets and liabilities were transferred to the plaintiff company. It is the case of the plaintiffs that the land which is in occupation of the defendant is a part of the Kalinagar Tea State. Included in the settlement survey Dag number 70 of the final Khatian number 3 of Moza Kalinagar, Jungle Block Part 1, Part 2 in Pargana, Garasati, in the district of Karimganj, and corresponds to resurvey Dag number 90 of Patta number 18. Under such circumstances, the plaintiff sought for a declaration that the plaintiff is the owner of the said land, which have been described in the schedule to the plaintiff, for recovery of khas possession of the suit land by evicting the defendants and all other members of their family, and by demolishing the houses, and for temporary and perpetual injunction. The defendants jointly filed a written statement stating inter alia that raising various preliminary objections it was categorically stated that the suit land is or was not the land of the plaintiff company and the Kalinagar tea garden. There was or is never any labor quarter of the plaintiff company and Kalinagar tea garden over the suit land. It was mentioned that the settlement survey operation of 1990-91, the suit land was not recorded in the name of the plaintiff company. The assistant settlement officer of Ramakrishna Nagar had illegally rejected the prayer of the defendant number 1 for mutation of the suit land in the name of the defendants. It was further stated that there are 3 plots which fall within the ambit of the suit land. The plot number 1, which have been described in the schedule to the written statement, was owned by one Muhammad Kamaruddin through inheritance, being the owner and possessor of the land on being the owner and possessor of the land. On 21/11/1984, by the registered deed of sale, bearing deed number 4106, the said plot of land described in plot number 1 of the schedule to the written statement was transferred to the defendant number 1. And the defendant number 1 thereupon have been residing over the said plot of land for the last 30-35 years by constructing homestead, by and also by planting various trees. As regards the plot number 2 of the schedule to the written statement, it was mentioned that the said land originally belonged to one Suaid, S-U-A-I-D, Suaid Ali of village Kalinagar colony, and through purchase and being owner and possessor, the said Suaid Ali transferred the said land, being plot number 2, to Akadas Ali, and the defendant number 1 by a registered sale deed number 1623 dated 22/10/1986 and delivered possession. It was claimed that the defendant number 1 purchased the land and became owner of 4 kedars of land, and since after the purchase he had been possessing the said kedar of land. In respect to the plot number 3 of the schedule to the written statement, it was mentioned that the said land originally belonged to one Riazuddin of village Daluganj through inheritance, and being the owner and possessor, he sold the land to the defendant number 4 by the registered deed of sale bearing 1387 dated 7/11/1994 and delivered possession to him. It was also mentioned that the suit land, including the lands which have been a part of the schedule to the written statement, was recorded in Dag number 70 of Moza Kalinagar Jungle Block Part 2 during the settlement survey operation held in 1960-61, while the said land was recorded in Dag number 90 of the said Moza during the then settlement survey operation. The original owner of the land of Kalinagar Tea Garden, along with the land covered by the aforesaid Dag number 70 old and 90 new, was MS Bharat Samiti. The said Bharat Samiti, by the registered deed of sale dated 25/7/1965, sold all the land except the land of Dag number 70 old, corresponding to new Dag number 90, and the land of old Dag number 89 to MS Sriram Tea Company. Thereupon, the said MS Sriram in the year 1974 sold all the land purchased from Bharat Samiti Limited except the land of Dag number 70 old, corresponding to new Dag number 790, measuring an area of 1149 bighas, 14 katha, 1 chatak, and the land of old Dag number 89, measuring an area of 50 bighas, to the authority of Kalinagar Tea Garden. It is under such circumstances stated that the plaintiff company, neither the plaintiff company nor the Kalinagar Tea Garden has authority or ownership over the land mentioned in the schedule below, that is the land covered by settlement survey Dag number 70 old and 90 new, and the land covered by old Dag number 89. On the basis of the said pleading, the learned trial court framed as many as 6 issues. Issue number 3 pertained to as to whether the plaintiff had right, title, and interest over the suit land, and issue number 6 pertained to whether the plaintiffs were dispossessed from the suit land by the defendants in the month of February 1998. It is also relevant to take note of issue number 2, which stipulates as to whether the suit land is properly described in the schedule of the plain, inasmuch as the same touches on the substantial question of law which have been formulated by this court. The learned first appellate trial court, while deciding the issue number 2, came to opinion that the suit land was not properly described and was not identifiable, and accordingly held that the issue number 2 in the negative and against the plaintiff. As regards the issue number 3, the learned trial court came to an opinion that the plaintiff have failed to show that they have right, title, and interest over the suit land, and accordingly the said issue was also decided against the plaintiffs. In respect to the issue number 5, to issue number 6, it is where? No issue number 6 decided.
Page 17, internal page, issue number 6 decided.
It is also seen that the issue number 6 was also decided against the plaintiff. Accordingly, by judgment and order dated 24/12/2002, the suit filed by the plaintiff, being title suit number 37/2001, was dismissed. Being agreed, an appeal was prepared by the learned first by the plaintiffs who are the appellants hearing before the court of the civil judge Karimganj. By the judgment and order dated 30/7/2007, the said appeal was dismissed by affirming the judgment and decree passed by the learned trial court. It is under such circumstances the instant appeal has been preferred, and this court have duly admitted the said appeal by formulating the said substantial questions of law. This court have heard Mr. G. N. Sahavala, the learned senior counsel, assisted by so and so, appearing on behalf of the appellants, and Ms. R. Chaudhary, the learned counsel, appearing on behalf of the respondents. Evidence. Mr. Sahavala, where have you shown that you have purchased 70?
My lord, that from the exhibit 1, my lord, that frequency violation.
Very.
Then exhibit 270 become 90.
Huh?
Exhibit 270 become 90.
Where?
Exhibit 1 is the 70.
Exhibit one is the Panel Khatian.
Yes.
What does it say? Where is it?
My lord, that put last page, my lord, of this 70 is there. Tag number 70. What is the
Where?
last part 1, my lord, last is 56.
Last is some 43. 43 and 50. What is this? Dagor number? Ne?
No. It's after that, sir. Another page. Yes.
70
70.
and 89.
Yes.
These belong to whom? In whose name the Khatian was there?
Hello, Community Limited. Kalinova.
Exhibit 1 was in whose name?
And then exhibit 2, my lord, 70 becomes 9.
In whose name?
It's just part committee. Limited.
Bharat Committee. Bharat Committee Limited.
Yes. Kalinagar T. Kalinagar tea.
And there you have dark number 90.
Yes. It becomes that one.
70 became 90.
Right.
This is the Kacha Kacha in the name of Bharat Committee.
Our committee of Kalinagar tea.
Okay. Then Bharat Samiti sold it.
Yes.
They say that 70 was not sold.
And their garden has been sold.
How do you sold it?
That is it. Exit 7 miles.
Yes. Tell me. We are running out of time.
The third page, my lord, that is given. Third page of the deed.
They say the
Yes.
land was not sold.
The vendor is absolute seized and possessed on well sufficiently entitled to the tea estate known as Kalinagar tea estate, situated in PS so and so, General Subdivision, Karimganj, District, Kachar, Assam, together with all immovable and movable properties appertaining thereto, free from all encumbrances and liabilities whatsoever. That is land comprised in the state tea estate according to nature and tenure thereof in the respective subject to the payment of revenue, rent, and local food. But this is the entire test regarding. The vendor hereby agree for that the rent procedure for absolute sale to it from the first day of January 1973 of the state calendar code P state. Area going concern in edge comprising several pieces of parcels of land described in the entire calendar code P state.
That deed has not been produced.
No.
Then how are you saying that you should have produced? That is your stand. No, it is your stand. They have never said that. On the other hand, the document which have been exhibited to DW4 makes it clear that they still retain 466 bighas of land. No, they retain. They retain 5 and 70. You see, out of 70, the total land which was there was total land of 70 was some
252 bigha.
no. The total land of 70 was 316 bighas 5 katha. Okay. And 20 is 570. And out of 70, excess land was found at from 70, which became 90, 253 bighas was found as excess land from Khatian 1. Okay. So these, along with dark number 5, 61, 315 it became, was taken out as excess land.
As per Exhibit E, Lordship. That is Exhibit E.
Exhibit E. But anyways, your predecessor could not have had the right.
Those were not exhibited. Only that deed I have with me, and I have gone through that some lands were not sold to the Sriram Tea Company as because, Lordship, those
No,
lands
that,
were requisitioned.
madam, we are not going to go into those fictitious
Lordship.
things about not going to those things. What is Exhibit 7? Exhibit 7 is the document by which a sale was being made by three companies to Guttu and Company
Yes, Lordship.
partnership.
Para 3 says says about something about lease, Lordship. Para 3 of that deed, Lordship. The vendor both hereby covenant with the purchaser that the.
There are three, name and style, Guttu and Company, where?
No, Lordship, internal page 15.
15 of that deed.
Lordship.
There are three. It's difficult. 6, 5. Entitled to state known influence of
Now this indenture witnesses as follows, and thereafter para 3, Lordship. That is page 15.
see the first schedule. Where do I get the first schedule?
His lordship, that is after para 6, the first schedule above referred to.
Where?
Page 20, lordship.
Of the deed.
Yes, sir.
The deed has no page.
But lordship,
Mm.
the bottom part, it is referred as continues to 21.
The first schedule here to end. Therefore, the first schedule above referred. Those piece and parcel of the land held under the government of Assam in the district of Toronto subdivision. You fall in which Tozi?
Hello?
What was your Tozi?
The deed is in handwritten, lordship.
That is what is very difficult for this.
Lordship. But I am having the type copy, lordship.
This also I have now been able to get it. A is Tozi 17, account number 15. What is the plaint? What are they asking in the plaint?
Hello, tag number 70.
Huh?
Tag number 70.
No. What is Tozi? How do we know which dark number? There is no dark numbers mentioned in this.
Only land pertaining to settlement surveyed dark number 70 of final Khatian number 3 of Mauja Kalinagar Jungle Block Part 2 in Porgana Egarosati of the erstwhile district of Kachar, now Karimganj, and corresponding to resurveyed dark number 90, Patta number 18.
That is there what they have stated in the plaint. In the schedule.
They are only concerned about dark number 5 and 70, but their exhibit, the purchase deed did not mention any dark. At that relevant point of time, maybe there was no dark lordship.
So it is all Tozi. So how do they correlate? The
So
Tozi?
and their schedule also, lordship, in boundary, entire boundary mentions in all the sites, only lordship Bagan. East, west, north, and south, the land of the plaintiffs under Kalinagar Tea Estate corresponding to settlement survey dark number 5 and 70. So whether our land, we always denied that the suit land does not attract to our possessed land.
Now how they, first of all, your here, whatever may be, there is an order of the settlement officer.
Lord.
The settlement officer says that 70 and 89 were given to them. How do you take care of that? You see the settlement order, officer's order. Maybe for in another case, but
that,
it has
that was later on challenge, and that was maybe lordship dismissed by the revenue board. Revenue board held that lordship those dark numbers allotted to the Tinagar are not correct. Their entry in entry of name of Guttu and Company in lordship revenue records is not correct. That was the finding of the revenue board.
and Mr. Ayula, how do you bring it? The purchase was made by partnership firm.
Hello?
Purchase was made by the partnership firm. How do you bring in the company?
No, there is partnership firm, my lord.
Huh?
Partnership firm.
No, it's a company.
Oh, no.
See the plane.
No,
That without showing that document, how could you? And where is the correlation of yours with that dark number 70? And why
my
it
lord,
was,
this has been in para 2, I have stated.
that is what you have said.
Yes.
That is pleading. Where's the proof? Where's the transfer to the plaintiff company?
In settlement operation also, it has been recorded in the name of the plaintiff.
Forget about the that is another application,
So
another
that is why, my
proceeding.
lord, it has been
I'm
transferred.
not that. But how do you correlate?
Because it has been transferred to the.
There is a transfer, isn't it, for you to show your document of title? Where is your document of title?
There are still some other RSAs also are also pending, Lordship, before this court. RSA 65 of 2022.
Not necessarily.
the
Don't
same
bring so many cases. One is enough.
No.
Of the official state. 5 minutes. Hello. I don't see anything. You're not shown his document of title. How is it possible? No. The first substantial question of this court, and Arthur really, the first substantial question of law so formulated is as to whether the judgment of the courts below are perverse to the fact of the case in coming to a finding that Exhibit 7D is not specific because dark numbers are not mentioned about Exhibit 7, although Exhibit 7 contains the TOSI number and the account number of different plots of land, which clearly proves that the appellant purchased the entire Kalinagar tea estate and the suit land. In the opinion of this court, the said question of law cannot be substantial, cannot be a question involved in the instant appeal, taking into account that a perusal of Exhibit 7 only mentions about TOSI, only describes the land in the first schedule as TOSI along with account. But however, there is no correlation with the said TOSI and the account so mentioned in the Exhibit 7 with the corresponding DAGs. In the pleadings as well as also in the evidence. In addition to that, this court also finds it very under such circumstances, this court is of the opinion that the said substantial question of law so formulate is not involved in the instant appeal The second substantial question of law is as to whether the judgment of the appellate court is perverse, being not passed on the pleadings and evidence on record, as no oral evidence have been considered by the learned appellate court. This court have duly taken note of that the judgment of the trial court and also of the first appellate court, wherein it appears that the material evidence have been duly taken note of. Under such circumstances, the said substantial question of law so formulated does not arise in the instant appeal. At this stage, this court finds it very pertinent to take note of that in the plaintiff or the appellant herein, it has been mentioned to be a company registered under the provisions of the Companies Act 1955 or 56. Mr. Sayola, your plane says 54, but I think it is 56. 56. However, the document of title which have been shown is Exhibit 7, wherein the name of the deed of sale have been made in favor of a partnership firm. And this aspect of the matter has also been admitted in the plaint. However, there has been no relation, no pleading, no proof has been given as to how and on what basis the said partnership firm transferred the land in favor of the plaintiff company. Under such circumstances, it is the opinion of this court that the plaintiff had completely failed to discharge its burden, for which the instant appeal burden in terms with Section 101 of the Indian Evidence Act 1872. Accordingly, the instant appeal, accordingly, this court is of the opinion that both the courts below were justified in dismissing the appeal, the suit filed by the plaintiff. Consequently, the appeal stands dismissed with cost quantified at rupees 20,000 for the instant proceeding. In addition to that, the plaintiff defendant shall be entitled to cost throughout. What is the other one?
Same lordship.
Same.
Lordship. Almost same lordship, but the purchase did same.
That's position, my lord, that's purchase.
We'll take the other one on some other day. We'll have it on Thursday. The other one on Thursday. It's the matter on Thursday. Top of the list.